Kowski, Mr. Brewer.
Thank you, Mr. Castor. On behalf of Lanny Brewer and myself, we do have some preliminary remarks that we would like to make. Mr. Smith is committed to providing information to this committee about the work of the Special Counsel's Office, while following all laws and rules restricting a former prosecutor's ability to disclose certain information. To that end, we appreciate the committee's assistance in working with the Department of Justice to provide Mr. Smith with authorization and clarification on the parameters around Mr. Smith's testimony today. Of course, some restrictions remain on Mr. Smith's testimony, two of which I would like to highlight before we begin. First, as the committee is aware, in its letter of December 11th, 2025, the Justice Department admonished Mr. Smith that he is not authorized to divulge information that is prohibited by law or courts, including that which is subject to Federal Rule of Criminal Procedure 6E. It is our understanding from communications with the committee and the Justice Department that DOJ is interpreting a matter under Rule 6E to be limited to the inner workings of the grand jury. On a call with committee staff and with the Department of Justice on December 11th to discuss the scope and application of grand jury secrecy requirements, Assistant Attorney General Patrick Davis agreed with Mr. Castor's statement that based on DOJ's authorization letter and its interpretation of Rule 6E, it would be virtually impossible for DOJ to prosecute Mr. Smith for violating grand jury secrecy restrictions. Second, according to the Justice Department, discussion of Volume 2 of the Special Counsel's report and any information or conclusions in Volume 2 or in drafts thereof is specifically prohibited by Judge Cannon's January 21st, 2025 order. This morning, just over an hour ago, the Department of Justice sent us an email affirming its view that Judge Cannon's order applies to Mr. Smith and that it precludes him from disclosing any non-public information that may be contained in Volume 2, including, but not limited to, interview transcripts, search warrant materials, business records, toll records, video footage, records obtained by grand jury subpoenas, attorney-client communications, and potential Rule 404B evidence. This restriction significantly limits Mr. Smith's ability to discuss the classified documents case. Nevertheless, Mr. Smith is committed to doing his best to answering questions consistent with the department's guidance. And I ask that that email from the Department of Justice that was sent earlier this morning be made part of the record.
That'll be Exhibit 5.
Thank you. I also want to clarify that the email from the Department of Justice says that Mr. Smith can disclose information in answering questions where that information is in the public record and has been made publicly available through authorized means. And I want to specifically cite that language because yesterday the Department of Justice disclosed to Senator Grassley some emails related to the execution of the search warrant at Mar-a-Lago. I anticipate that those emails may be used during today's deposition and that Mr. Smith may be asked questions about that search warrant and the probable cause supporting the search warrant that was signed by a judge in the Southern District of Florida. And I just want to confirm our understanding that because those emails were released by the Department of Justice to Chairman Grassley, everyone here has a mutual understanding that those emails were made publicly available through authorized means.
And we would concur with that. In our discussion with the Justice Department, and it was in the context of the member toll records subpoenas, they indicated that documents that are in the public realm are fair game for discussion and don't apply to the 6E prohibition, the disclosure of 6E material. And we would further acknowledge that if Senator Grassley posted these materials on his official website, that is an authorized release. I mean, these are materials that were produced to the House and the Senate, and if Senator Grassley posted them publicly, they are certainly part of the public record.
Thank you, Mr. Castor. We are in agreement.
Mr. Castor, can I just note one thing for the record, that counsel for the minority have not been involved in any of the discussions that Mr. Kosky just discussed between the Judiciary Committee and Department of Justice. I just want to make that clear for the record.
All right. Noted.
Thank you. My understanding is that if, for whatever reason, the questions today move into an area that we believe Mr. Smith cannot answer because of some legal restriction, we have reached an agreement with the committee staff that we will raise our concern in the moment to see if we can navigate around the restrictions. And if we are unable, we will move on to another topic and then revisit that issue during a break or at the end of the day. Yes.
Just to augment what my partner said, we had proposed to the Department of Justice that it have a lawyer here present today, so that if any issue came up, we could immediately resolve it, because Mr. Smith is committed to answering every question he can lawfully. The Department of Justice chose not to have a lawyer here today.
Thank you. Finally, I feel compelled to make an observation about the risks of participating in this deposition. The most powerful person in the world has said that Mr. Smith should be in jail because of his work as special counsel. Not because Jack did anything wrong, but because he had the audacity to follow the facts and the law and apply them to that powerful person. And through its actions, this Justice Department has demonstrated its eagerness to follow President Trump's orders, despite the facts and the law. Yesterday, the President's Chief of Staff is reported to have confirmed in interviews that the President is indeed pursuing criminal prosecutions against his perceived adversaries as part of a retribution campaign. In the face of those threats, Mr. Smith appears today undaunted, comforted by the knowledge that not only did he do nothing wrong, he conducted his work as special counsel with integrity, impartiality, and an uncompromising commitment to the rule of law. If the committee will allow, Mr. Smith has some remarks that he would like to share.
Okay, before that, I would just note from Exhibit 4, the December 11th Justice Department letter, they specifically say, the last paragraph on page 2, as to your question about the department's recent disclosure to Congress of certain internal communications considering whether to authorize toll record subpoenas, which Congress publicly released on November 25th, 2025, you are correct that the department does not believe that the specific materials it produced to Congress are covered by 6E for the reasons described above.
Thank you, Mr. Castor. That's helpful. We are in agreement on that. My concern is that that doesn't address Judge Cannon's order, which the department has said Mr. Smith is still bound by because the toll record subpoenas were not part of the classified documents case. And so Judge Cannon's order is a separate legal restriction that exists independent of Rule 6E.
Okay. And I would just note on our call with the Justice Department, their position was, of course he can talk about it if it's in the public realm. And that admonition from the department was not limited to the toll records question or something in Judge Cannon.
Thank you.
Mr. Smith, you had some remarks as well?
Yes, thank you. Thank you for the opportunity to discuss my work as special counsel. I was taught as a young prosecutor to follow the facts and the law, and to do so without fear or favor, to do the right thing the right way for the right reasons. For nearly 3 decades, I've been a career prosecutor. I've served during both Republican and Democratic administrations, and I've been guided by those principles in every role I've held. I continued to honor those principles when I was appointed to serve as special counsel in November of 2022. The decision to bring charges against President Trump was mine, but the basis for those charges rests entirely with President Trump and his actions, as alleged in the indictments returned by grand juries in 2 different districts. Our investigation developed proof beyond a reasonable doubt that President Trump engaged in a criminal scheme to overturn the results of the 2020 election and to prevent the lawful transfer of power. Our investigation also developed powerful evidence that showed that President Trump willfully retained highly classified documents after he left office in January of 2021, storing them at his social club, including in a ballroom and a bathroom. He then repeatedly tried to obstruct justice to conceal his continued retention of those documents. I remain grateful for the counsel, judgment, and advice of my team as I executed my responsibilities. I am both saddened and angered that President Trump has sought revenge against career prosecutors, FBI agents, and support staff simply for doing their jobs and for having worked on those cases. These dedicated public servants are the best of us, and they have been wrongly vilified and improperly dismissed from their jobs. I made my decisions in the investigation without regard to President Trump's political association, activities, beliefs, or candidacy in the 2024 presidential election. We took our actions based on the facts and the law, the very lessons I learned early in my career as a prosecutor. We followed Justice Department policies and observed legal requirements. The timing and speed of our work reflects the strength of the evidence and our confidence that we would have secured convictions at trial. If asked whether to prosecute a former president based on the same facts today, I would do so regardless of whether that president was a Republican or a Democrat. Recent narratives about my team's work are false and misleading, including stories about our collection of toll records. Toll records were sought for historical telephone routing information, collected after calls had taken place, identifying the incoming and outgoing call numbers, the time of the calls and their duration. Toll records do not include the content of calls. Those records were lawfully subpoenaed and were relevant to complete a comprehensive investigation. January 6th was an attack on the structure of our democracy in which over 140 heroic law enforcement officers were assaulted. Over 160 individuals later pled guilty to assaulting police that day. Exploiting that violence, President Trump and his associates tried to call members of Congress in furtherance of their criminal scheme, urging them to further delay certification of the 2020 election. I did not choose those members. President Trump did. I hope that my testimony today serves to correct these mischaracterizations about my work, and to that end, I welcome your questions.
Can we get a copy? Do you have a copy?
I'm sure.
We can get you a copy, yeah.
You just made some pretty definitive statements about, your belief that President Trump was guilty of these charges. Is that correct?
Yes, I believe we had proof beyond a reasonable doubt in both cases.
And doesn't the Justice Manual prohibit prosecutors from asserting that a defendant is guilty of something before a jury makes the determination?
When a case is pending, yes.
Okay, and so you think you're free from that, from the Justice Manual rules, once a case is dismissed?
No, I think that it's important to state clearly the amount of evidence we had and the basis for why we proceeded. Why we proceeded as we did is because we had a strong case, as I set forth in the final report.
But your final report makes what seems to be conclusive determinations of President Trump's guilt, as opposed to laying out simply the facts and the evidence that you have. I mean, you draw those conclusions that, in your view, he's guilty. Is that not the case?
Well, to be clear, the cases were never tried. We were never put to our burden before a jury, so we didn't conclusively prove it. The reason the report was written the way it was written, and the reason I said what I just said, is because it was our belief that if we went to trial, we would prevail.
But your report differs, if you look at Special Counsel Herr's report and Special Counsel Mueller's report, The language that you use and the way you describe the things that you believe President Trump committed, is different. Her was careful to use words like jurors could find or might, at most, would likely conclude, whereas the language you use is pretty definitive.
Her report states his assessment of the evidence. Mine does as well, and as I said, I feel and feel to this day that we had a very strong case, and so I communicated that.
Okay, but you would agree that it's the role of the jury, not the special counsel, to weigh the facts and to determine guilt?
Ultimately, yes.
Okay. And then one other thing about you relating to your statement, and we'll get into this a little later on, but the toll record subpoenas for members of Congress, we have some very serious concerns about acquiring these toll records, relating to senators and members of the House. I mean, members of the House and the Senate have protections under the Constitution that allows them speech or debate protections. And the toll record subpoenas, in our view, and if we had to litigate it, the House lawyers would take the position that those toll record subpoenas violated the speech or debate protections. And is that something you disagree with?
Yes.
Okay, and we'll get into that a little bit later. We first wrote to you on October 14th, inviting you to testify. And then we worked with the Justice Department and your counsel to make sure you had access to everything you needed to prepare for today. Did that occur? Did you have enough access to the information you need to prepare?
Yes.
Okay, so we asked the Justice Department to make all your files available, to allow you to go to the Justice Department whenever you wanted to, with your lawyers, whoever you wanted to. And I just wanted to confirm that you had the opportunity to review whatever you needed in your files before today.
Yes, we reviewed the files.
Okay.
That's correct.
There might be an issue with classified materials. We don't intend to ask you anything about anything classified. Obviously, if your security clearance is no longer valid, there's an issue on that front. But everything except classified information was supposed to be made available to you, and I just want to confirm that that was the case.
I'm not sure if everything was. For example, the emails of people on my staff. I'm not sure I had access to that, but we did spend, consistent with what you said, time at the Department of Justice, and we had the opportunity to review files.
And that access was made available early, like November 10th, if I'm not mistaken, and I think you guys started reviewing it somewhat shortly thereafter?
That sounds about right.
Okay. You have referenced in your pleadings, I believe, and also in public statements you've made, the famous Robert Jackson speech entitled "The Federal Prosecutor" that he delivered at the second annual conference of the United States Attorneys in 1940. You're familiar with the Robert Jackson speech?
I am, yes.
Okay. And this is widely available on the internet. I didn't make copies for everybody. Everybody can Google it right now as long as your phones are working. And I'm just going to flag some things that Robert Jackson said and just get your reaction to see if you agree with it or not. He says in the second sentence, "The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous." Do you agree with that?
I agree that prosecutors have a lot of discretion, yes.
Jackson stated, "While the prosecutor at his best is one of the most beneficent forces in our society, when he acts from malice or other base motives, he is one of the worst." Do you agree with that?
I do.
On page 4 of his remarks, in the penultimate paragraph, Attorney General Jackson states, "What every prosecutor is practically required to do is to select the cases for prosecution and to select those in which the offense is the most flagrant, the public harm the greatest, and the proof the most certain." Would you agree with that?
Yes.
If a prosecutor is obliged to choose his cases it follows that he can choose his defendants. Therein is the most dangerous power of the prosecutor, that he will pick people he thinks he should get, rather than pick cases that need to be prosecuted. With the law books filled with a great assortment of crimes, a prosecutor stands a fair chance of finding at least a technical violation of some act on the part of almost anyone. In such a case, it's not a question of discovering the commission of a crime and then looking for the man who committed it. It is a question of picking the man and then searching the law books or putting investigators to work to pin some offenses on him. Do you agree with that?
I do, I think, yes.
Okay. It is here that law enforcement becomes personal, and the real crime becomes that of being unpopular with the predominant or governing group, being attached to the wrong political views, or being personally obnoxious to or in the way of the prosecutor himself. Do you agree that that is a concern?
These are principles, and I agree with these principles.
Okay. In times of fear or hysteria, political, racial, religious, social, and economic groups often, from the best of motives, cry for the scalps of individuals or groups because they do not like their views. Do you agree with that?
Yes.
He concludes by saying the qualities of a good prosecutor are as elusive and as impossible to define as those which mark a gentleman. And those who need to be told would not understand it anyway. A sensitiveness to fair play and sportsmanship is perhaps the best protection against the abuse of power. And the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth and not victims, who serves the law and not factional purposes, and who approaches his task with humility. Do you agree with that?
Fully.
And do you think during the pendency of your special counsel work that you tried to live up to those standards?
I do.
Was there ever a prospect after you were appointed special counsel when you thought maybe you would not bring an indictment against President Trump?
Absolutely. When I took this case, I did not know enough about the facts or the law to have a judgment about whether we should proceed in either case, both cases, or neither case. I used my time when I was appointed to get up to speed on the facts and the law. But if the facts and the law did not justify going forward in this case, I would have been perfectly comfortable in doing that, as I have throughout my career in cases involving political figures when I was in public integrity and throughout my career. So I did not have a preconceived outcome in mind when I took this job.
Was there any point where you and your prosecutors that formed your team debated not bringing charges against the president?
Of course. I mean, that is the process of being a prosecutor, is you are analyzing evidence, you're collecting facts, and you're debating whether it's what the facts mean, the inferences to be drawn from the facts, or debating what the law is, and whether you can prove what you think is happening here or not. And so that was a continual process to decide if in fact we could go forward. And that, again, just to be clear, that is a process that I have undergone in my career personally and with prosecutors I've supervised.
When was the decision made that you believed you needed to move forward with both indictments, both in Florida and D.C.?
Well, so the decision wasn't made at the same time. To the best of my recollection, in both cases, the final decision was shortly before we sought indictment.
Okay. In June of 2023, you had a meeting with the Attorney General to present a prosecution memo and basically asking for his blessing to bring the indictments. Is that correct?
We did have a meeting, and I think it was around that time. I didn't think about it as his blessing. I was presenting what I intended to do, and he had the ability to countermand that if he wanted to.
Okay. But certainly, you couldn't bring an indictment without his authorization.
He could block me from doing that. That's correct.
Okay. And during that June 2023 meeting with the Attorney General. Did you guys discuss both indictments, potential indictments? Or just the Florida indictment or just the DC indictment?
If it was, I don't have a specific recollection of dates, and so you can check me on public records, but I believe by late June, the classified documents case had already been indicted.
Okay.
So again, this is my recollection, but that would have been, a discussion in late June would have likely been about just the elections case,
Okay.
if it was about an indictment.
Okay. And the Attorney General in the June meeting, it's been reported that he expressed some reservations about the DC case. Is that correct?
I had several meetings with the Attorney General about both cases, and in those meetings, we regularly discussed legal issues, factual issues, things of that nature. Never in those meetings did he tell me I couldn't or shouldn't go forward or should go forward. It was more talking through with another experienced lawyer the legal issues present in the cases, as well as if I was going to go forward, how to best frame those.
Okay. Coming out of the June meeting, it's been reported that he asked you to spend some time with the Solicitor General to review the DC case. Is that correct?
Again, I don't recall specific conversations. What I can share with you is we consulted with the Solicitor General regularly during my time as special counsel. That was a choice I made. We wanted to make sure not only that we got the facts right, but that we got the law right as well. And so I would be surprised if the first time I consulted with the Solicitor General would have been in late June. That would surprise me.
Okay. But you did have a one-on-one meeting with the Solicitor General in person?
I've met the Solicitor General in person. My recollection is most often it would be members of my senior staff speaking with her staff about these legal issues. I did have conversations with her as well, but the majority of that was her staff and my staff speaking about things.
Okay. And as it's been reported, the Attorney General at the time was concerned that the proposed indictment or the proposed prosecution plan, may have relied too heavily on statements that the president had made and infringed on his free speech if you were going to prosecute him for it. Is that fair?
As I sit here right now, I can't remember specific conversations. I do remember that we knew that a sort of First Amendment defense would be part of the case. And I think when I mentioned to you earlier about how to frame the case, we want to make clear that this was not about trying to interfere with anyone's First Amendment rights, that this was a fraud. And as you know, under Supreme Court precedent, fraud is not protected by the First Amendment. And so in my mind, it was important to make that clear in the indictment. And that's why when we litigated this issue before the district court, we prevailed.
But the president's statements that he believed the election was rife with fraud, those certainly are statements that are protected by the First Amendment, correct?
Absolutely not if they are made to target a lawful government function and they are made with knowing falsity. No, they're not. That was my point about fraud not being protected by the First Amendment.
I mean, there's a long list of disputed elections. I mean, the election of 1800, 1960, year 2000, where candidates believe they were wronged by because they lost. And there's a long history of candidates speaking out about they believe there's been fraud, there's been other problems with the integrity of the election process. And I think you would agree that those types of statements are sort of at the core of the First Amendment rights of a presidential candidate, right?
There is no historical analog for what President Trump did in this case. As we said in the indictment, he was free to say that he thought he won the election. He was even free to say falsely that he won the election. But what he was not free to do was violate federal law and use knowingly false statements about election fraud to target a lawful government function. That he was not allowed to do. And that differentiates this case from any past history.
A lot of these statements, though, people come into the Oval Office. I mean, the president isn't conducting his own due diligence. He is receiving people in his office that are telling him these things, whether it be Rudy Giuliani, whether it be John Eastman, whether it be Jeffrey Clark, whether it be Sidney Powell. And, for the most part, he is just receiving this information, and, his statements are almost just regurgitating what these people have told him. I mean, isn't that the case?
No, and in fact, one of the strengths of our case and why we felt we had such strong proof is our witnesses were not going to be political enemies of the president. They were going to be political allies. We had numerous witnesses who would say, I voted for President Trump. I campaigned for President Trump. I wanted him to win. The Speaker of the House in Arizona, the Speaker of the House in Michigan. We had an elector in Pennsylvania who is a former congressman who is going to be an elector for President Trump, who said that what they were trying to do was an attempt to overthrow the government and illegal. Our case was built on, frankly, Republicans who put their allegiance to the country before the party. And so the president got information from people he trusted on other issues. He rejected it whenever it didn't fit him staying in office. And there was a pattern in our case where anytime any information came in that would mean he could no longer be president, he would reject it. And any theory, no matter how far-fetched, no matter how not based in law, that would indicate that he could, he latched onto that. And we were confident that we had very strong proof of that pattern. He also, I would just add, very consciously did not try to reach out to the sort of people who have the most expertise on these issues. He reached out to people who he thought could back him up.
Yeah, but let's be honest. The president doesn't reach out to anyone. People are brought to him. I mean, he doesn't, like, the people you mentioned that you were going to call a trial, those aren't, some, Pennsylvania Republican official. I mean, that's not somebody who was in the Oval Office communicating with the president.
Well,
right?
Well, with respect to the Arizona Speaker of the House, that is someone the president reached out to. He also reached out to governors. He reached out to the governor of Arizona. He reached out, and again, Republicans, his allies. Our case was a case in which the president was preying on the party allegiance of people who supported him. And these are, again, the record is rife with examples of him reaching out to those people, inviting them to the White House. And another example, sir, is the folks from Michigan. He invited them to the White House. They told him, you lost because you underperformed with educated females. They told him that when he brought them there. And again, our case was filled with examples of that.
Were you planning on calling John Eastman as a witness?
I do not believe we would have, but we would have welcomed if the defense called him.
Okay. It gets tricky, though, for the defense to call him because the people like Eastman and Clark and, Rudy Giuliani and Sidney Powell, I mean, they were shrouded by the special counsel as, co-conspirators 1 through 6. And so they all feared that they were going to be prosecuted if they said anything. Isn't that fair?
Well, they were co-conspirators. I can't get into what was in their mind or not. I can tell you some of the co-conspirators met with us in proffers and did interviews with us. And so the idea that someone like Rudy Giuliani, who sat with a proffer for us, he was available as a witness, and we would have welcomed President Trump calling him as a witness. Boris Epstein sat for an interview with us. We would have welcomed calling him as a witness. Kenneth Chesborough, we would have welcomed it.
Why didn't you charge any of those folks?
I'm sorry?
Why didn't you charge any of those co-conspirators?
As we stated in the final report, we analyzed the evidence against different co-conspirators. My staff determined that we did have evidence to charge people at a certain point in time. I had not made final determinations about that at the time that President Trump won re-election, meaning that our office was going to be closed down.
Right. You've had a 30-year career as a prosecutor. You've prosecuted gang members, right?
Yes.
You've prosecuted organized crime members, right?
Not as much.
But, surely one of the, fundamental principles of prosecutorial work is you work from the bottom up, and you try to get as many fact witnesses to work with you. And a lot of times those fact witnesses have criminal liability, and a lot of times those lower fact witnesses, the smaller fish, are almost always they're either prosecuted or they are given an immunity because they fear they're going to be prosecuted. But here you didn't, you kept laser focused only on President Trump.
2 points. One, as I said, we were considering prosecutions of these people, and I think I don't want to say what the ultimate conclusion would have been, but that was something that was being considered. The second thing I think to understand contextually is this was a case where the issue was how to present it in a concise way. We had so many witnesses, so many witnesses who were allies of President Trump available to us to testify. This was not a case where we needed more witnesses. It was a case where we needed to be able to present the case in a streamlined way because there was so much evidence.
In this book by the Washington Post reporters on page 310, you're familiar with this book. Have you read it? It's called Injustice by Lenig and Davis.
No, I have not read it.
Are you familiar with it?
I have not seen it. I mean, I saw that it came out in the news, but I have not read
Okay.
it.
Did you cooperate with the book? Did you talk to Carol Lenig or Aaron Davis?
They reached out to my counsel. I did not speak to them.
And did you ever speak with them during your tenure at the Justice Department?
No.
Anyway, they report, and these are reporters. They get some things wrong. They called Chairman Jordan the chairman of the Senate Judiciary Committee. They said Speaker McCarthy voted in favor of the second impeachment, and I can confirm that it's just laughably inaccurate. And so reporters get things wrong, and so if that's the case, please flag it. But in the book on 310, the reporters write, as each new tranche of information about fake electors came in, members of Smith's team intermittently raised the idea of opening separate case files on Giuliani, Eastman, and others. Each time, however, Smith dismissed the idea. He said he did not want the office getting bogged down and potentially prosecuting those around Trump. Is that?
I don't think that's accurate. I did make the decision that the first case we brought was going to be Donald Trump, and I was aware that there was evidence against other people, but I don't think that characterization is accurate.
Okay. Now, people with different views than you can say the special counsel's office is only interested in prosecuting President Trump because an election's coming up and he's going to be the Republican nominee. And the special counsel works for a Democratic president. The special counsel works for a Democratic attorney general. And so the special counsel's laser focus on President Trump is simply to prevent him from either being the party's nominee or being a successful party's nominee, or at the very least, keeping him off the campaign trail. How do you respond to that?
All of that is false, and I'll say a few things. The first is the evidence here made clear that President Trump was, by a large measure, the most culpable and most responsible person in this conspiracy. These crimes were committed for his benefit. The attack that happened at the Capitol as part of this case does not happen without him. The other co-conspirators were doing this for his benefit. So in terms of why we would pursue a case against him, I entirely disagree with any characterization that our work was in any way meant to hamper him in the presidential election. I would never take orders from a political leader to hamper another person in an election. That's not who I am, and I think people who know me and my experience over 30 years would find that laughable.
So did you develop evidence that President Trump, was responsible for the violence at the Capitol on January 6th?
So our view of the evidence was that he caused it and that he exploited it and that it was foreseeable to him.
But you don't have any evidence that he instructed people to crash the Capitol, do you?
As I said, our evidence is that he, in the weeks leading up to January 6th, created a level of distrust. He used that level of distrust to get people to believe fraud claims that weren't true. He made false statements to state legislatures, to his supporters, in all sorts of contexts, and was aware in the days leading up to January 6th that his supporters were angry when he invited them, and then he directed them to the Capitol. Once they were at the Capitol and once the attack on the Capitol happened, he refused to stop it. He instead issued a tweet that, without question in my mind, endangered the life of his own vice president. And when the violence was going on, he had to be pushed repeatedly by his staff members to do anything to quell it. And then even afterwards, he directed co-conspirators to make calls to members of Congress, people who were his political allies, to further delay the proceedings.
Did you sought gag orders in both the Florida case and the DC case, is that correct?
We sought an order in the DC case under Rule, I think it's 57.2, and we did that because Donald Trump was making statements that were endangering witnesses, intimidating witnesses, endangering members of my staff, endangering court staff. As you might remember, in the right around when the indictment was released, he issued a tweet saying, "If you come after me, I'll come after you." He called, in a tweet, he called General Mark Milley a traitor and mentioned that what he'd done in olden times, people would be put to death. As a result of the things he was saying, the judge in this case was received vile death threats. And with respect to the DC, both the district court and the Court of Appeals, a panel of judges, found that his actions were in fact causing what we said they caused. They were causing witnesses to be intimidated and endangering people. And I believe it was the Court of Appeals also found that in addition to intimidating or chilling witnesses who existed, it would chill witnesses who had not yet come forward because they'd afraid that they would be next. So yes, we did file that, and I make no apologies for that.
I mean, which witnesses do you think he would have intimidated? I mean, are there any specific witnesses did you identify for the court?
We did a filing. I don't recall the specifics in that filing right now, but as I said, one of the issues from my perspective was not only the witnesses who he had specifically called out and caused threats to be issued, this phenomena that was found by both courts. It was the result of that is that a rational witness who maybe had not come forward would be completely afraid to, because they would see that they would be next. And I think both courts agreed with that.
Well, I mean, the Circuit Court of Appeals ultimately slimmed down the gag order, isn't that correct?
It did, yes.
And what was the difference between the gag order you proposed and Judge Chutkan agreed to and the final gag order that the DC Circuit approved?
Okay, I'm going to go off my recollection. I know one of the differences was him making threatening statements towards me personally was was allowed. I think in the district court in our application, we thought that shouldn't be allowed. I will share with you that I told my staff that it was much more important to me that he not be able to issue threats to court staff and my staff than me. And so the Court of Appeals did narrow it in that way. And as I'm sitting here now, I'm not debating you that they narrowed it. I just can't remember these specific details.
Okay.
But the phenomena, they concurred that the phenomena I'm describing to you today was real. And
Okay.
it had real-world consequences.
18 United States Code 1512 here deals with tampering with witnesses. Did you identify any violations of 18 USC 1512?
We did not bring any charges.
And did you allege that he violated any terms of his release?
We did not.
I want to turn to the member toll records topic. What's the difference between a subpoena for toll records and a 2703D order?
Well, subpoena for toll records is non-content. Doesn't have any content, doesn't have like the header of, say, an email, things of that nature. Whereas I think if I'm correct in the terminology, I think a 2703D would be regarding emails and could have information like that.
Could have content?
Well, at least again, this is my recollection. I haven't looked at this issue in some time, but I think it means it's not content, but it could at least have, say, the header like of the message, like not the content of the message, but it might include the header.
Did you use any 2703D orders on members of Congress or senators or their staff?
I do not recall that at this time.
Did you use any pen registers? Like, maybe just walk us through what a pen register is and trap and trace.
Yeah, my understanding or my recollection is a pen register or trap and trace is a thing where you're watching who someone's calling going forward. Like, so, if there was a trap and trace on my phone, it would see going forward from today who I called. And a pen register, I'm mixing up the terminology, but one is like calls in and the other one's calls out.
Okay. And did you use any of those techniques on members of Congress, senators, or their staff?
I don't recall anything like that.
Okay. And when you say you don't recall, you think the answer is no, but you're not able to give a definitive answer?
Yeah, I have nothing in my memory that tells me that we did anything like that.
Okay. And so with the toll record, so as it relates to members and their staff and senators, it's just the toll records as far as you remember?
That's my recollection.
Okay. And
Well, I'm sorry to interrupt you.
Yeah.
Before I was special counsel, the people who were working on one of the investigations did get a search warrant for the cell phone of one Congressman
Perry. Yes, we are very familiar with that. With the toll record subpoena, maybe just walk us through like what you get. You get the incoming, the telephone numbers that call a particular cell phone, right?
That's correct.
And you get the time that the call occurred.
Yes.
And you get the length of time of a call?
I believe that's correct.
Okay. And you also get the list of numbers that the outgoing. You get the incoming and the outgoing, right? That's
correct.
And is there any other information that the toll record subpoenas provide?
That is the what I understand is the major thing you're seeking to get with the toll record subpoena.
Okay. And when you get one of these subpoenas, you just send it to the carrier, correct? Doesn't involve the judge.
The subpoena? Yes, that's correct.
Okay.
Doesn't require a judge.
The only time a judge gets involved is if you're seeking a non-disclosure order, is that right?
If it's a subpoena for toll records, that's correct.
Okay. And do you always seek is it the practice of your team to always seek the NDO?
Well, in this particular case, there was a grave risk of obstruction of justice, given the obstructive conduct of President Trump as is set forth, for example, in the indictment in Florida. President Trump tried to obstruct that case in multiple ways. As I mentioned earlier, in the litigation we had regarding 57.2, we had numerous instances of him attempting to, in our view, intimidate witnesses or keep them from cooperating. And so given that reality, we did seek non-disclosure orders for the toll record subpoenas you're talking about.
Okay. And ordinarily, you just go to, how do you pick your judge for that when you're seeking the NDOs? Some of them were signed by the chief judge, and then others were signed by a Magistrate Judge David Baker, at least as it relates to the members. How do you pick the judge? Or do they pick it for you?
I don't know that we picked the judge. I have to say, in my role in this, I wouldn't have known that.
Okay.
I don't know that even a prosecutor can pick the judge, but
Okay.
I don't know what local practice in Washington D.C.
Okay.
would be on that.
I mean, sometimes I think Boasberg signed the NDOs for the senators, and then as it related to Speaker McCarthy and some of our members from the Judiciary Committee, it was the Magistrate Judge David Baker. And so you don't have any idea why the...
Well, a common practice in my experience as a prosecutor, certainly when I was a prosecutor in Brooklyn, is there'll be a duty judge or a duty magistrate, and so whoever has duty that day is who you go to.
Okay.
I just want to be clear, in this case, I don't have a recollection if that's how it works in D.C., but it may well have been that way.
Okay. And these NDO orders, at least the ones we've seen, they're all the same. Is that a fair statement?
I think they're usually very similar, yes.
Okay. And you submit a proposed order, correct, for the judge to sign?
That's correct.
And part of the language in this states that the court finds reasonable grounds to believe that such disclosure will result in flight from prosecution, destruction of or tampering with evidence, intimidation of potential witnesses, and serious jeopardy to the investigation. Is that something you remember?
Yes, those are the in the law, and the number is escaping me right now, but in the law that sets forth the reasons why you could get a non-disclosure order, I believe those are the different prongs, if you will, of that statute.
As it relates to members of Congress and senators and their staff, definitely their staff as well, I mean, that presents concern that we don't have an opportunity to, quash the subpoena. How does your office deal with that prospect?
Well, the nature, and I should also be clear that when you're getting an NDO, say for toll records, it's not based on an allegation that necessarily the person who has the phone number is personally going to obstruct the investigation. It's that if this gets out, people could obstruct the investigation. So I want to make that clear. Second point would be, you are correct in that inherent in getting an NDO is that at various times, people who might have arguments about why to quash a subpoena won't be able to make those arguments. In our investigation, this came up with Twitter. We wanted to get records from Twitter regarding President Trump. Twitter, and we applied for an NDO from the judge. Twitter refused to provide the records unless they could tell President Trump about that. And so we had litigation with this in the district court. The district court agreed that there are situations, and there it was that Twitter argued that President Trump should be able to assert executive privilege over the records we wanted. And as a result of that litigation, the district court found that it was proper of us, given the level of obstruction in this case, to get that NDO. That decision by the district court was upheld by the Court of Appeals. And then that decision by the Court of Appeals, Twitter, my recollection is Twitter sought to get the Supreme Court to overrule that, and the Supreme Court refused to. And so I tell you all that to say,
And then you find them, right?
well, actually, that's before. They refused to comply even after she ruled, and she set a schedule of fines, and so part of the appeal was...
But you sought the fines, right?
Absolutely, yes.
Okay.
But the point of telling you that was that inherent in an NDO is it may be that certain arguments about why a subpoena should be quashed can't be made. So that happens, and I think there's a parallel in those situations.
When it comes to members of Congress, though, there are the speech or debate protections, which you totally sidestep. I mean, the toll records provide enormous, valuable information because it shows who a member of Congress, who a senator is taking calls from, and who they're calling. And if you map it up against the Senate or the House calendar, you can see what the inputs are to their legislative decision making, which is at the core of speech or debate. Do you agree with it?
My office and I personally take the protections of the speech or debate clause seriously. I think they're part of our Constitution. They're an important part of separation of powers. I think our respect for the speech or debate clause is evidenced by the litigation we engaged in this office. We conducted litigation with Congressman Perry and also Vice President Pence, taking that very seriously. And I would just also add that my office had folks who were really the department experts on speech or debate. And when we sought these subpoenas, we got approval from Public Integrity, who are the sort of keepers of that issue.
Yeah.
And they concurred in us getting these subpoenas.
They did, and we saw some of that email traffic, and I would respectfully disagree with their view of the speech or debate law, as you might imagine. When you sought these non-disclosure orders, the judge didn't know it was a member of Congress. Is that correct?
I don't think we identified that because I don't think that was department policy at the
Okay.
time.
And you had some litigation substantial litigation with Congressman Perry over the seizure of his phone, but you didn't have any litigation with us over the seizure of members of the Judiciary Committee's phones because we never knew about it.
That's correct.
Sorry, I just want to clarify. I think you said regarding the seizure of any senators' phones?
Representative Perry had his phone seized.
Yes, but are you suggesting that there's a seizure of a senator's phone?
No.
Okay, I just wanted to clarify that. Thank you.
The only seizure I'm aware of is Congressman Perry. Do you know of any other seizures?
That's the one I recall.
Okay. So no other members of Congress, no other senator had their phone seized?
I don't recall.
Did you seek search warrants for the content of any, of the telephone calls or the content relies mostly to text messages? Did you seek a search warrant for the content of any text messages from members?
From members?
Yeah.
No, I don't recall
Okay, it
that.
was just toll records.
Correct.
Okay. But by not telling the members, by going through this NDO process, I mean, they didn't have an opportunity to litigate the speech or debate concerns.
That's correct.
And that's unfair, in our view.
I understand your position, and as I said before, we respect the speech or debate clause. I'm aware of no case in the Supreme Court or the D.C. Circuit that says that getting non-content toll records from a third party violates the speech or debate clause, particularly where, and I think an important point here, is these records were not sought to use against members of Congress who were targets. The investigation we were conducting was of President Trump and his co-conspirators, who were all obviously not members of Congress, but also private, not even members of the White House.
I mean, the House and DOJ has a big disagreement on this. I mean, the William Jefferson case, you familiar with the Rayburn House Office Building case?
I am.
Okay. And so when issuing grand jury subpoenas for toll records, do you consider yourself bound by that opinion?
Yes, but I would say that opinion does not deal, that isn't a case where there was a search warrant of a congressman's office. That congressman was a target of the investigation. The search warrant wasn't seeking non-content toll records. It was seeking the actual records, legislative material of the congressman to be used against that congressman.
Right. But, I mean, the court in the Rayburn case concluded that there is a documentary non-disclosure privilege, not just a prohibition on the evidentiary use of that material against members.
I'm not debating the Rayburn case exists. What I'm saying is in the Supreme Court of the D.C. Circuit, there is no case that says non-content. Rayburn dealt with content. Non-content records, not secured from a member, but secured from a third party, are subject to the speech or debate clause. And if I may, the correspondence we talked about, that reading, which was the reading of my staff who are very familiar with this, was consistent with the department's position on those issues, and public integrity, which was sort of the keeper of this issue, concurred in our getting these subpoenas.
We're making exhibit, we up to number 6?
Yes.
And this is some back and forth. What Exhibit 6 is going to be an email between your office and Public Integrity regarding the Senate, the toll records for the senators.
Thank you very much.
Thank you.
Thank you very much.
The relevant, these documents are helpfully not based.
Yeah. If you want to show me yours, I can look for it here.
Okay.
This one.
So the department has, if you're going to, has requirements for all prosecutors that, if you're going to bring a tax prosecution, you have to consult with the tax division, right?
Correct.
If you're going to bring a national security related case for classified mishandling of classified documents, you need the National Security Division to okay that, right?
Correct.
And as it relates to, sensitive political matters, the Attorney General has to okay, and there's been a series of memos, both from Attorney General Barr and Garland and so forth, correct?
Sensitive political matters, I'm not sure if that's the terminology. There's an election year sensitivities
Yeah.
memo, and there's also regulations,
Right.
specific regulations for specific situations, yes.
Right, and the FBI calls it a sensitive investigative matter, and, they need to get they can't do anything without getting the director of the FBI to okay, getting search warrants against members of Congress and so forth, correct?
I'm not as familiar with the FBI regulations as the DOJ regulations.
But is public integrity, before you seek member toll records, is the hoop you have to jump through public integrity?
So it was for my office because I directed my staff to consult them anytime we were going to do that. I understand that was more of a practice and tradition. It's since become a specific requirement after these toll records were issued, but it was my policy to do that, and it was, again, consistent with my policy of wanting to sort of leverage the expertise in the department. So we did that.
Is this back and forth, and your staff had a memo that it, I think, basically put an email And then Public Integrity responds with this message. Is that essentially the extent of the back and forth with Public Integrity?
I don't know that this is the extent of it. There's a line here that says, "As you are aware." That makes me think that there was also a telephone conversation, but I don't, just to be clear, I don't have a specific recollection of that. I told my staff that in this situation, if we're going to seek these toll records, you need to consult with Public Integrity. As you can see from the email chain, I wasn't on that email chain.
Were there any other boxes you had to check? Did you have to tell the Attorney General or the DAG to get these toll records, or was it just you and Public Integrity?
My direction was to tell for our staff to go to Public Integrity. It may well have been that this is the sort of thing either I would have briefed the Attorney General on, or J.P. Cooney, who was our contact with the leadership of the department, may have told them about. But the thing that I was most concerned about was making sure Public Integrity, who was the sort of the experts on this issue, that they were consulted.
I mean, this isn't, if you look at the email, it's not that fulsome, right? It's not a complete analysis of the constitutionality or even the propriety of the call record subpoenas under the speech or debate clause. I mean, is that fair to say?
Yes, certainly there could be more analysis, but again, I don't know if there was an additional conversation that, it seemed, I'm drawing an inference, I don't recall this,
Right.
but this seems to me to indicate there may have been an additional conversation.
So the email, from our perspective, it seems to be a cursory litigation risk assessment. It's not, it doesn't raise the issues that we would raise if we were litigating the speech or debate matter. Because, I mean, our position is that the toll record subpoenas do violate speech or debate. I mean, if you get a list of all the people calling members of the Judiciary Committee before a floor vote, that is pretty core protected material. This back and forth with Public Integrity doesn't address very much. Is that fair?
Well, again, I don't know if there were additional conversation or conversations. I also don't know, frankly, if this is the only email on this issue. So I don't think I would call it cursory. I think an important context here is that the people involved in this, including the people on this email chain, as well as one of my senior counselors, Ray Hulser, who is really the department's expert on these issues, that these are people with expertise in this area discussing it with one another.
But if you believe what the Washington Post reporters wrote in their book, they say, according to their sources, that you were legendary for being dialed into, every last detail of these cases. That you were, they stopped short of calling you a micromanager, but they say that, you looked at, witness outlines, 2 days before witness interviews. Is that fair?
I did that with outlines of interviews, yes.
And you had, at points, you had daily meetings with the teams, and you wanted to know, every last detail of your case. Is that fair?
I try to be a responsible supervisor, yes.
But when it comes to taking the members of Congress, phone records, you weren't as plugged into that. Is that fair?
No, I don't think that's fair. I spoke with my staff about this. I ultimately approved it.
Right.
I had faith in the expertise of my staff. They discussed it with me. I felt there was a basis for it. I felt it was relevant and material to the investigation. And I also felt comfortable because I knew that my view about that would be tested by an analysis of public integrity.
Well, look at the last sentence. Low likelihood that any of the members listed below would be charged, and the litigation risk would be minimal. Not to mention, they're not going to know. So the assessment is, as Steve described, pretty cursory. We're not going to charge anyone. We're not going to get sued. They're not going to know. Who cares about speech or debate? That's what the assessment looks like to me. Your response?
Chairman, I would disagree with that characterization of it.
Well, that's what the sentence says. We're not going to charge these people. I doubt if they take us to court. It'd be hard for them to take us to court because they're not going to know for years that we did this. Move ahead. And you said fine to
I approve these subpoenas, yes.
Okay.
And, our view is this is inconsistent with the DC Circuit case law, which establishes that the speech or debate protections includes a non-disclosure privilege, period. It's not just a privilege against using that material against the members. It's also a privilege against taking that information and using it against a third party. If you're going to prosecute Jeff Clark with Scott Perry's phone records, we believe that the DC Circuit holds you can't do that. And this back and forth with public integrity doesn't factor that in. That's concerning to us. Did you have any discussions with the Office of Legal Counsel or the Solicitor General's office? Were there any other components in the Justice Department that analyzed this?
On this discrete issue, I don't have any recollection of those entities being involved in that discussion.
Okay. And there's a statute regarding Senate phone records. Are you familiar with 2 United States Code 6628?
Yes.
And did you analyze or factor in that statute before you issued the subpoenas for the senator toll records?
As I sit here today, I don't recall specifically discussing that statute. I will say that my reading of that statute as it existed at that time is that that was a statute directed at providers. It actually envisions that a provider might actually get an NDO application, and the provider who has the best information about whose phone line is whose, that they're best situated to make these judgments.
Okay, so that was my next question, is like, whose responsibility it is to flag that there's a statute, a law, that bars NDOs with regards to certain Senate phone numbers? Whose responsibility? Is that the special counsel's office? Is that the carrier? Is that the judge? Does the judge have to sort of figure this out? The magistrate judge? Certainly the magistrate judge doesn't have to figure it out like all on his own, does he?
Well, that statute, as I said, my reading of that statute, the language of that statute as it existed at that time, is that it's the job of the carrier, and to me that makes sense because they're the ones who have the best and most accurate information about whose phone lines are whose. They actually have that information.
Okay. But the package of materials that you send off to the magistrate judge or the chief judge, whoever the duty judge is, as you mentioned, you don't identify that it's a Senate phone number or a member of Congress in those applications. So there'd be no way for the judge to know that there's these additional considerations. Is that fair?
I think that is fair. I think the department guidance on that issue has changed since these events we're talking about. And so now if one were to do that, you would notify the judge.
Okay, and my time's up, so unfortunately I have to leave it there. We'll go off the record.
Mr. Smith, let's just start with the bottom line up front. One of your investigations focused on whether any person violated the law in connection with efforts to interfere in the lawful transfer of power following the 2020 election. Is that correct?
Yes.
At the conclusion of that investigation related to the interference in the lawful transfer of power following the 2020 election, when your office indicted Mr. Trump for his criminal scheme to overturn the 2020 election, did you believe that you had sufficient evidence to obtain and sustain a conviction against Mr. Donald Trump?
Yes.
For these charges stemming from Mr. Trump's criminal scheme to overturn the 2020 election, did you believe that you had sufficient evidence to prove these charges beyond a reasonable doubt?
Yes.
And we know that it's more than just a reasonable doubt. Did you believe that there were multiple substantial federal interests in proceeding with prosecuting Mr. Trump after he attempted to criminally overturn the 2020 election?
I did.
Now, the second investigation that you were appointed to lead focused on the possession of highly classified documents at Mr. Trump's Mar-a-Lago social club following his presidency. When your office indicted Mr. Trump for willfully keeping highly classified docs after he lost the 2020 election, did you believe that you had sufficient evidence to obtain and sustain a conviction against Mr. Donald Trump?
Yes.
And for these charges stemming from when Mr. Trump left the office in 2021 with these highly classified documents, did you believe that you had sufficient evidence to prove the charges beyond a reasonable doubt?
Yes.
And did you believe that there were multiple substantial federal interests in proceeding with prosecuting Mr. Trump for his unlawful possession of these highly classified documents?
I did.
How many years of experience do you have as a prosecutor, Mr. Smith?
In total, I've been a prosecutor a little short of 30 years.
Can you give us a high-level overview of the different offices you might have worked in as a prosecutor?
Sure. I started my career as an assistant district attorney at the Manhattan District Attorney's Office in New York City. I prosecuted local crimes there for 5 years. Afterwards, I became a federal prosecutor in the Eastern District of New York, which is in Brooklyn and Long Island, and I was there for about 9 years. I prosecuted larger, more complex cases when I was there. I was eventually the chief of criminal litigation there. I left that office to go overseas and work at the International Criminal Court for a little short of 2 years. I coordinated investigations of the Office of the Prosecutor there. I then returned to the Department of Justice, where I was the chief of the Public Integrity section of the Department of Justice, and I did that for somewhere between 4.5 and 5 years. I left Washington, D.C., and moved to Nashville, Tennessee, where I was the first assistant U.S. attorney and then later the acting U.S. attorney in the Middle District of Tennessee, which is in Nashville. I left government for the only time in my career. I was worked for a private company for a brief period of time, a period of months, and then I was offered a position by the State Department to serve as a war crimes prosecutor at a European Union war crimes tribunal in The Hague, the Netherlands, and I was there for a little over 4 years before I became special counsel.
I'm sorry to interrupt. Can you just speak up a little bit?
Oh, I'm
I know-
sorry.
Yeah, the people in the back have trouble hearing you.
Sorry about that.
And can you describe the types of cases out of all these years of experience? Just give us a broad overview of the seriousness of the case that you've brought in your career.
I've worked on all sorts of cases. Early in my career, I was a member of the offices in Manhattan, the domestic violence unit, and so I did a number of cases of people who are abusing domestic violence victims. Those are some of the most memorable cases in my career. I worked on gang cases, RICO gang cases, in the Eastern District of New York. I worked on the Abner Louima case, which was a assault of a Haitian immigrant by police officers. I did other an international murder for hire case, other sorts of violent crime cases. I was one of the night of 9/11. I was part of the command center, and in the weeks afterwards, I was involved in responding to what happened on 9/11. After the Eastern District of New York, when I was overseas, I worked on war crimes cases that were in all sorts of different jurisdictions and all sorts of challenging investigative situations. And political corruption cases, obviously, when I was in public integrity and also in Nashville.
So taking all these cases you described, I heard cases about, gangs in New York, it sounds like. There were war crimes cases, there were domestic violence cases you just described. Taking all that experience, when you finished your investigation at Special Counsel's Office, you believed that you had sufficient evidence in this case to prove Donald Trump committed those crimes after the 2020 election?
I did.
And you believe that you had enough evidence to get a conviction with Donald Trump willfully taking the classified documents after he left office in 2020 and returned to Florida in 2021?
That's correct.
So we've heard a word a lot from this administration, from the majority Republicans, and that word is transparency. And yet, Mr. Smith, we're in a closed-door deposition today, meaning that members of the public and even congressional members and staff who are not part of the Judiciary Committee are not permitted to attend this proceeding. Did you offer to testify publicly before this committee?
Yes.
How did you offer? How did you make the offer to testify publicly to this committee?
I think it was through my counsel.
Did you send a letter to the committee? Did your counsel send a letter to the committee offering to publicly testify?
I think that's right.
We'll enter that letter into the record just for your background. And this will be Exhibit 7. It'll be an October 23rd, 2025 letter signed by Mr. Lanny Brewer and Mr. Peter Koski. It's addressed to Chairman Jordan and Chairman Grassley regarding Mr. Smith's public offer to testify publicly. Are you familiar with this letter, Mr. Smith?
Yes.
Can you tell us why you felt it was important to make a request for a public hearing?
I'm proud of the work that we did at the special counsel's office. I'm particularly proud of the people I worked with, the career public servants I worked with, who've been vilified by President Trump and people who work for him, and I think someone needs to speak up for them.
Did you want to testify publicly because you had something to hide about your investigation?
No.
Did you want to testify publicly to rebut some of these accusations from the president that you just mentioned about your investigation?
Yes, that's what I meant. Accusations not just against me, but against career prosecutors, career FBI agents who have served our country and who've been vilified wrongly. I think it's really important to correct the record on that.
Were you granted the request to testify publicly before this committee? The answer's probably obvious as we sit in this room, but were you granted that request?
No.
Were you given any reasons or provided any reasons why you were not allowed to testify publicly and directly to the American people?
I don't recall that.
Are you aware that even President Trump thought that you should testify publicly before our committee?
I heard that.
Yeah, just to make it clear for the record, Mr. Trump said, and this is a quote, "I'd rather see him," as in Jack Smith, "testify publicly because there's no way he can answer the questions." So let's turn to a few of those questions. Do you recall the October 14th, 2025 letter to you from Chairman Jordan requesting a transcribed interview?
I know he sent a letter asking for me to be interviewed, yes.
We'll enter that into the record and make it Exhibit 8.
Thank you.
And I'll give you a second just to look through it as we pass it out. So in this October letter to you requesting a transcribed interview, the chairman characterized your investigation as, quote, "politically motivated prosecutions of Donald J. Trump," end quote, and said you conducted a, quote, "unnecessary and abusive raid of the residence," end quote, of Donald Trump, and that claimed that you, quote, "manipulated key evidence in the investigation," end quote, among other claims. Do you recall these accusations to you in the letter from Chairman Jordan?
Yes.
The Republicans of our committee have made these letters to you public. You can read it on the committee's website, including these accusations that your office was weaponized. But this proceeding is behind closed doors, and Majority Counsel just warned you earlier about keeping the contents of this deposition confidential. Do you remember that warning that you received at the beginning of this deposition?
Yes.
So we will get into this in more detail later, but just to quickly touch on this, do you agree with the majority's characterization that your office was weaponized?
No.
Was your special counsel's office weaponized in any way?
No.
Did you conduct a politically motivated prosecution of Donald J. Trump?
I did not.
Would you like to have explained directly to the American people why these characterizations are not true?
Yes, and again, particularly as to the career prosecutors and agents who've been vilified.
Are you concerned that given that this deposition is not open to the public and the public cannot hear your answers or observe your demeanor or hear the way that you're responding to questions from the majority, that some of your responses may be selectively published or released in a way that mischaracterizes your answers?
I would hope that wouldn't happen.
But are you aware that's a risk of your testimony here today?
I'm sure that's possible.
Based upon your knowledge, is it generally the practice for the special counsel who investigated presidential conduct to be given the chance to testify at a public hearing to be able to explain their findings to the American public?
Yes.
So let's just take a few of those. Are you aware of special counsel Robert Mueller testifying publicly before the House Judiciary Committee?
Yes.
For the record, that occurred in July of 2019. Are you aware of special counsel John Durham testifying publicly before the House Judiciary Committee?
Yes.
For the record, that occurred in June of 2023. Are you aware of special counsel Robert Hur, who came up earlier in the majority's hour, testifying before the House Judiciary Committee?
Yes.
For the record, that occurred in March of 2024. Also want to touch a little bit on, speaking of just transparency and a fulsome investigation into this committee's request for documents related to your investigation. We're going to enter into the record another letter from Chairman Jordan. This one's addressed to Attorney General Bondi. This letter seeks records related to the Arctic frost files, and it's dated October 29th of 2025. This will be Exhibit 9. And you might not be familiar with this document, so I'll give you a second to review it. It's not very long, though.
Okay, I've reviewed it.
So after reviewing it, are you now aware that Chairman Jordan has sought the production of files related to your investigation from the Department of Justice?
Yes.
And just to read that request, it's request number 2. It says, in quotes, all DOJ documents and communications referring or relating to Jack Smith's special counsel investigation for the period of November 18th, 2022 to January 20th of 2025. I just want to get a better understanding of this broad request of all DOJ documents and communications referring to your investigation. I guess what types or categories of documents are associated or would be associated with your investigative files?
There would be numerous documents. I mean, it was a prosecutor's office, so the sort of documents you would associate with a prosecutor's office.
Just to make it clear for the record, can you just give a few examples of what those records or memos might look like or what they might be about?
Prosecution memos, email correspondence with my staff, analysis of the case, things of that nature.
Would these documents include internal decision memos or other records of major decisions made by you and your team during the investigation?
Yes.
Do these files include communications with the Attorney General or the Deputy Attorney General during the course of your investigation?
I don't think I had any files that would fall into that category. I'm not sure if there'd be, my deputy also communicated with the Deputy Attorney General's office, so there may be, but I don't think that's to me.
Do these files include communications just with other DOJ offices? I think earlier you mentioned possible communications with the Solicitor General. Would those files include possible communications with that person?
Yes.
Could I just follow up on that for 1 sec?
Sure.
You had no communications with the Deputy Attorney General?
No, I took the question to mean in terms of like email or things of that nature. We met, I met with the Attorney General, the Deputy Attorney General, at times at their request. So those things did happen. I'm just saying I don't recall me having any sort of email communications with either of them.
But in terms of the special counsel offices, just following up Mr. Golden's question, the office as a whole, if there were email communications between members of your team and the Attorney General or the Deputy Attorney General, would that probably be a part of your special counsel case files?
Yes.
And as far as you're aware, the current Department of Justice has full access to your documents and memos and files from your investigation, is that correct?
They should.
In fact, you reviewed those files in preparation for your appearance today, right?
Yes, we were given access to a computer that had files on it. I can't say that it's all the files, but we were given access to that, and I reviewed that in preparation of today.
Did you follow DOJ protocol in your decision-making, including consulting with relevant offices like the Public Integrity Section, the Office of Legal Counsel, and any other entities as required and encouraged by DOJ policy?
Yes.
Were there examples where these consultations were memorialized in writing, either before or after you met with these offices?
Yes.
So given the majority's claim that the investigation was biased, do you think the case files would help eliminate some of the majority's questions about the actions you took while special counsel?
I have no objection to people looking at the case file.
To your knowledge, has DOJ released all the special counsel's files, either to Congress or to the public?
I don't know what they've released to Congress.
Do you believe it's in the public's best interest to view the full case file rather than just selective samples as they've come out so far?
The reason I'm pausing is I'm not sure it's proper for me to weigh in on that. I don't know if there are, for example, confidential information regarding witnesses that shouldn't be made public. And so I think that's a matter for others besides me who have the case files in their possession now to review and decide.
So let's just narrow it a little bit. Do you think it would be beneficial for the committee to review the case files so we can understand why certain investigative steps were taken.
I'm going to leave that to others to decide. I'm here, and I'm happy to answer any questions you or anybody else might have.
If the case files were released, would they include any political considerations by you or your team as you investigated and charged these cases?
We did not consider politics. I did not consider politics, anyone's politics in charging these cases.
And that would be borne out, presumably, by the case files?
I'm not aware of anything in the case files that would contradict that.
Because it never happened.
It never happened.
I also just want to note the authorization that you got from DOJ, and I think this is marked as Exhibit 2. No, sorry, Exhibit 3 by the majority. It was quite broad, right?
Which one is this now?
This is Exhibit 3, a letter from the Department of Justice to your counsel.
I have my own copy.
Apologize, we've got a lot of letters here,
It's
so.
okay. Take your time.
Just don't have a lot of evidence
Here you go.
that's been disclosed.
Okay, I have the letter now,
Okay,
yes.
so I'm looking at page 3 on the bottom, but this letter essentially walks through a series of topics that you are authorized by the DOJ to discuss.
Correct.
So on the bottom of page 3, I'm reading here from the letter. The extraordinary events underlying this matter constitute exceptional circumstances warranting an extraordinary accommodation to Congress in this particular case. Given these extraordinary circumstances, to the greatest extent allowable by law, the department authorizes Mr. Smith to provide unrestricted testimony to the committee, irrespective of potential privilege, including the names of line attorneys and agents in the department as it pertains to the matter identified in this letter, and as limited in paragraph 1 through 5. And the paragraph 1 through 5 essentially goes through the investigations that you undertook and I guess a couple of tangential matters related to the Office of Professional Responsibility and the Arctic Frost investigation. Is that correct?
That's what that says, yes.
Okay. So given that DOJ gave you unrestricted or authorization to provide unrestricted testimony, would it make sense that DOJ then should also give this committee unrestricted access to the case files that's currently in its possession?
I'll leave it to others to decide that. I will say that the paragraph you read is different than it's been with past special counsel. Past special counsel usually testify about the contours of their report. They've changed the process here, and I'm still here willing to answer questions.
Okay, thank you.
We're going to, I believe we're on Exhibit 10 now. We're going to move on to Exhibit 10, which will be your special counsel report, Volume 1, dated January 7th of 2025. I know this is a document. I know this is a document you're very familiar with, but we'll pass it around. So as the date of your report says, on January 7th of 2025, and as your time as special counsel was coming to an end, you provided a final report to the Attorney General where you explained the prosecution and declination decisions that you made as special counsel as required by 28 CFR 600.8. Is that correct, sir?
That's correct.
What was your goal in preparing this report?
I wanted to, at first, make sure I fulfilled the obligation under the special counsel regulations to do a report consistent with the regulations.
And was this final report an accurate account of your investigation and its findings?
It was.
Based upon your understanding, is it generally the practice for a special counsel's report to be made public to the American people?
I believe so. I know at times they've been, portions have been redacted in the past, but my general understanding is yes.
To the best of your knowledge, do you recall Special Counsel Mueller's report being made public?
It was public, yes.
To the best of your recollection, do you recall Special Counsel Herr's report being made public?
Yes.
To the best of your knowledge, do you recall Special Counsel Weiss's report being made public?
I don't recall. It may be, I don't know.
Was your report made public in full?
This report as to the elections case, I believe it was made public.
Did you have a separate volume or a volume 2 of your report?
That's correct.
Was that made public?
No.
Touching on volume 2, in your letter to the Attorney General, you also recommended that volume 2 of this report, which discusses the classified documents case, not be publicly released while the cases of Mr. Walt Nauta and Mr. Carlos de Oliveira remain pending. Do you recall saying that in your letter to the Attorney General?
That's what's in the letter, yes.
Can you explain, please explain why you included that recommendation?
When, as special counsel, when you draft a report like this, it's not for me to decide whether it gets made public or not. It's for the Attorney General, and it's for him to also to decide what portions, if any, get redacted in that. And so what I stated was my, in essence, recommendation that it should not be public because these cases are pending and there are facts in here that it might not be fair to have that be public while they have charges pending against them.
Understood. So other than the fact that the cases of Mr. Nauta and Mr. Oliveira were still pending, as you just discussed, did you have any other reasons to believe or to recommend that volume 2 of the report should not be publicly released?
Well, again, that wasn't my choice. My choice was to write a report for the Attorney General to make a decision about whether it would be public. I have no objection to it being public, and I didn't then, as long as it complies with the law in terms of 6C and other issues like that.
Yeah, but just going back to that recommendation, in making the recommendation in the letter that it not be made public, understanding that it's the AG's decision to release the report, did you have any other reasons for making that recommendation other than the ongoing cases of Mr. Nauta and Mr. Oliveira?
I'm sorry, I misunderstood
Yeah,
your
of
question. No reason other than that.
Is there any other reason right now, since Mr. Nauta and Mr. Oliveira's cases are no longer pending, is there any reason now that you can think of, other than Judge Cannon's order, where volume 2 of the report should not be released?
Judge Cannon's order is the reason.
Excuse me, can I jump in? Do you know who was responsible? Did you dismiss the Nauta and Oliveira cases?
No.
Do you know who dismissed them?
I don't recall, but I imagine it's a matter of public record.
If I told you that it was after Donald Trump was inaugurated, would you agree with that?
I don't recall, but if that may well be true.
For the purpose of this remaining conversation, since that's a publicly identifiable fact, I will represent to you that it was done by the Trump administration. You charged that case, correct?
Correct.
You went through your extensive experience as a prosecutor. Do you believe that Mr. Nauta and Mr. Oliveira were guilty of the crimes that they were charged with?
Yes, we believed that we had proof beyond a reasonable doubt for all the charges and that we would have gotten convictions at trial, yes.
And are you aware of any reason within the rules, protocols, and regulations of the Department of Justice that that case should have been dismissed?
In my view, no, it shouldn't have been.
Real quickly, before I turn over to Mr. Jayapal, are you able to speak about volume 2 today?
I'm not.
Can you explain what you can and cannot speak about with respect to volume 2?
Well, there is an order of Judge Cannon, an injunction regarding Volume 2. I want to make very clear that I do not want to do anything to violate that injunction or that order. And so, given that I have not seen, looked at Volume 2 since I submitted it to the Attorney General almost a year ago, I do not have a exact recollection of what is in there and not. And so, unless something is in a public filing or, and people can point me to a public filing, or in, I think the category that was mentioned in the letter that we got this morning of publicly, I can't remember the terminology, but properly publicly released information. I do not want to, I want to be clear, I do not want to violate that order, and I don't want to do anything that could even be remotely construed as violating that order.
Wait, so, I'm sorry, but DOJ did not let you review volume 2 of your report?
It may well have been there, but I chose not to review it because I didn't want any implication whatsoever that I was somehow violating the order by looking at it, not being a member of the department now.
So before we go to Ms. Jayapal, I just want to clear up two things. One, so you've been an assistant DA, you've been a federal prosecutor, you were an international criminal court prosecutor, you were the chief of the public integrity section at DOJ, and you were first assistant U.S. attorney in Nashville and the acting U.S. attorney. Do you have any idea how many cases you've actually handled and prosecuted?
That I've handled or supervised others handling,
Yeah.
I'm sure it's in the thousands.
In the thousands, okay. Have you ever been prosecuted for selective prosecution, vindictive prosecution, or partisan discrimination?
Never.
Have you ever fired a prosecutor because they refused to engage in a prosecution on grounds that there was not sufficient evidence?
No.
Okay. And in all of the cases that you have supervised and prosecuted yourself directly relating to domestic violence, relating to conspiracy, relating to murder, relating to war crimes, have you encountered the problem of witness intimidation?
Very much so.
Will you speak a bit about the problem of witness intimidation and what that does to the rule of law and justice?
Witness intimidation is probably the most corrosive thing that can happen to the rule of law. And that is why, as a young prosecutor, you are taught to move your cases expeditiously, because you know that if there is someone trying to obstruct your case, the longer they have to do that, the more they can subvert justice. And I've worked on a number of cases. I've worked on murder cases where witnesses were murdered. I've worked on cases overseas involving very serious witness intimidation and obstruction of justice, and as I mentioned earlier, this case as well. And so that was foremost in my mind as we were conducting these investigations, but it's something I've encountered in different contexts throughout my career, even back to those domestic violence cases that I started in earlier in my career. Attempts to threaten or influence those witnesses are a way to subvert justice.
So what kinds of actions and precautions can you take as a prosecutor to prevent it and to try to protect witnesses against intimidation and violence?
So depending on the situation, there would be different sorts of steps that you could take. Obviously, if it's an imminent threat, like someone's coming to kill the witness today, you try to move them and protect them for a period of time. But if it's a more pervasive threat, where a defendant or people on his behalf are issuing statements and issuing threats, trying to get people not to cooperate with your case, or trying to make an example of people who have cooperated with your case, the best thing you can do is limit their ability to make those threats and shorten the time they have to make those threats.
Thank you. Let me go to Ms. Chapman.
Can I just, one thing on volume 2 before we go? It's obviously a case related to classified documents. Without getting into the detail, how was it constructed? How was it written? Was there an unclassified portion and a classified portion, or is the classified material interwoven in the volume?
I don't think I should even talk about that. I don't want to have any implication that I gave some sort of insight about how that report is constructed. And so I don't really think I could speak about that given her order.
Can I ask you this question? Is it possible to release parts of that report while also protecting classified material?
I very much want to answer your question, but I don't want to say anything that will imply what is in the report, and so unfortunately, I don't think I can answer.
Okay, again, I'm going to go to Ms. Jayapal. We'll come back to you. Yeah.
Thank you. Mr. Smith, I want to get to questions of transparency again, but I want to pull out to a bigger question. Do you think that it's important for our democracy to hold free and fair elections without interference or obstruction?
Yes.
And theoretically, what happens if there is election interference and the people who are responsible for that are not held accountable?
It becomes the new norm, and that becomes how we conduct elections.
And so the toll on our democracy, if you had to describe that, what would that be?
Catastrophic.
You stated in your testimony in the first hour that you've tried to be as transparent as possible with the American people about your investigation. The chairman of the committee has repeatedly put out that you were subpoenaed for your testimony today, and in fact you are here under a subpoena, but you have requested to appear voluntarily in a public hearing. Is that correct?
Yes.
And why were you willing to appear voluntarily in a public hearing?
We conducted our investigation in a way that I'm proud of. I'm particularly proud of the people I conducted the investigation with, and I wanted to speak for them.
And is it generally the practice of special counsels to appear in a public hearing? I know you have a couple of questions on this, but I want to reiterate this.
That is my general understanding, yes.
And can you tell us again why I understand you want to stick up for the prosecutors, the people that were part of the investigation. Can you tell us why it's important for the American people to hear directly from you about your investigation, what you discovered, the process that you went through?
Well, as I said in the beginning of, I think, my opening remarks, there have been mischaracterizations about my work. We did our work in the best traditions of the department, and I know I keep coming back to this, but the attacks, the mischaracterizations that most offend me are not just prosecutors, but career FBI agents, support staff in the department. These are people who devoted their lives to public servants, to being public servants. They have not, they're not self-promoters. They're not people who like to go in front of the cameras and defend themselves. And I feel that they have been vilified in a way that I think is awful.
What's the effect of that on our democracy?
Well, I think it drives people away from public service.
Yeah. Is it a form of witness intimidation?
I think it's even deeper than that. I think, you know, when we get to attacking the people who are the good guys,
Yeah.
I just don't know where that goes. It's counter to how I was raised.
And let me ask you, even after this deposition today, are you still willing to appear at a public hearing before this committee and speak directly to the American people about your investigation?
Yes.
Can I jump in really quickly just on the witness intimidation issue? As I understand it, you were asked a lot of questions about filings that your office made as it relates to trying to protect witnesses, specifically the gag orders. Do you have any regrets about the steps that you took as it relates to seeking gag orders against this defendant in an effort to protect witnesses?
Our applications for orders limiting Donald Trump's ability to intimidate witnesses, intimidate court staff, intimidate my staff, I have no regrets about that.
Dovetailing on that, have you only been further convicted in the decisions that you decided to make as it relates to that in watching some of the president's actions even in present day?
I think the record of our case speaks for itself on these issues.
Could I just follow up on the gag orders relative to the defendants? In every case, a judge decided that that was warranted, correct?
In the cases in the District of Columbia, a judge
Correct.
did decide that, and the Court of Appeals agreed. They narrowed the order, as I said earlier. In Florida, we applied for an order because of statements Donald Trump had made that I viewed endangered FBI agents. That hadn't been decided when the case was dismissed.
Thank you.
And just to kind of finish up on this point, You yourself, I'm not sure if this was discussed by the majority, but have you yourself been intimidated as a result of the actions that you took in this case?
I'm not going to be intimidated.
Have you been threatened?
Yes.
Have you learned of other persons, whether they worked under you as attorneys or other support staff? Are you aware of any threats that have been made against any of them?
Yes.
And, okay, I'll stop there.
Mr. Magoo?
Thank you, Mr. Smith. I really have two questions. First question, which our counsel ably covered, just so we're clear, you wanted to testify publicly today, correct?
Yes, I was willing to.
And Chairman Jordan declined that opportunity, correct?
Yes.
Any thoughts as to why Chairman Jordan is scared to have you testify in public?
I'm not going to characterize the chairman's decision. I offered, he decided that we would do it in this setting, and that is what it is.
Well, I think Americans who review this transcript, once it's concluded, will understand why. If you have any questions.
Marcus, let's come back to you.
Okay, thank you, sir. I'm going to switch gears a little bit to your appointment as special counsel. Do you recall when you were appointed as special counsel?
Yes, it was November, I believe, November of 2022.
Does November 18th of 2022 sound right?
That sounds about right.
Do you recall the day that Donald Trump announced his candidacy for the 2024 election?
I believe it was shortly before that.
So who offered you the position of special counsel?
The Attorney General.
And what was your understanding of why the Attorney General felt it was necessary to appoint a special counsel in this circumstance?
I believe the Attorney General made a public statement about why, and that public statement is my understanding.
We can maybe enter that public statement in a little later. But what did you understand the scope of your investigation to be specifically when you were appointed?
The scope was defined by the appointment order, which encompassed the two investigations that I've referred to today.
And can you just make the record clear again, just briefly describe those two investigations and then appointment order?
Sure, and I don't have the order in front of me, so just generally.
Actually, so we'll make that an
Yeah.
exhibit. We'll make it an exhibit. Let's make the appointment order an exhibit. And this will be exhibit 11, I believe. Make it easier just to refresh your
Sure,
recollection.
thank you.
So after you've taken a minute to review it, and please take your time, the question will be, what did you understand the scope of your investigation to be?
Okay, so consistent with this order, the scope was two investigations, both of them ongoing at the time. The first was an ongoing investigation into whether any person or entity violated the law in connection with efforts to interfere with the lawful transfer of power following the 2020 presidential election or the certification of the Electoral College vote held on or about January 6, 2021, as well as any matters that arose or might directly arise from this investigation.
Do you know why, or have you heard why the Attorney General chose you to be the special counsel?
Why he chose me?
Yes.
No,
Okay. At the time of your appointment, I understand you were living in the Netherlands. Is that correct?
that's correct.
Did you lobby for this position?
No,
Did you petition the Attorney General to be the special counsel?
I did not.
Did you reach out to any former colleagues of the Department of Justice expressing your interest in being the special counsel?
I had been in contact with a former colleague by the name of Marshall Miller. He had returned to the department sometime that summer, and I had spoken to him and expressed to him an interest in, if there was the right position, returning to the department.
Ultimately, why did you accept the special counsel position?
Because I thought I was the right person for the job. I knew that this would be a challenging job. I knew it would be a job where whoever held the job, or whatever decision they made, somebody would want to attack them for that decision. And I felt that given my nearly 30 years as a prosecutor, it made me uniquely qualified to do the work.
Did you have any reservations about accepting the special counsel position?
No?
There were a lot of attacks on you shortly after you were named and throughout the time as special counsel. You said earlier, I think you used the term intimidated. I guess, how did you move forward consistently with those attacks while special counsel?
I think attacks and praise are noise, and as a prosecutor, I've learned to tune those things out. I'm more concerned, again, about the attacks on my staff. But for myself, I understand that that's can be part of the work at times.
Did you accept the role, as some have suggested, because you had animus towards President Trump?
No.
Did you accept the role, as some have suggested, because you hoped to influence the 2024 presidential election in favor of the Democratic nominee?
No.
Did you accept the role because you thought it would help the Democratic nominee by prosecuting Donald Trump before the election took place in 2024?
No.
Let's consider the same facts related to the attack on the Capitol on January 6th or the mishandling of classified documents. So that's the facts that we're going to consider here. Take the same facts but insert a president who was a Democrat. Would you have still accepted the role of special counsel?
100%.
Considering the same facts, so the same fact pattern of the attack on the Capitol on January 6th, the same facts of unlawfully taking classified documents after leaving the White House, would you still have accepted the role of special counsel to investigate former President Barack Obama?
Yes.
Again, considering the same facts, would you have accepted the role of special counsel to investigate former President Joe Biden?
Yes.
Looking back, and you've talked about the investigation steps that you've taken here in the deposition today. I think I've heard you talk about, process of an investigation and how that's important. Would your investigative process have differed if the President of the United States would have been a Democrat?
No.
Someone have a follow-up on that?
Yeah. I served on the January 6th Select Committee, and we spent a lot of time looking through the criminal statutes that may have been implicated in the attack on the peaceful transfer of power, the attempt to overthrow the election, and then the violent assault on the Capitol. And we, in our conclusions, cited a number of statutes which ended up, I think, being part of your investigation, including conspiracy to obstruct a federal proceeding, conspiracy to defraud the United States, false statements, and so on. But you added something which I think was very interesting, which was a conspiracy to violate voting rights, which is something that we hadn't done. And I wonder if you would take a moment to expound on why you thought you had sufficient evidence to prove beyond a reasonable doubt that there was a conspiracy to violate the voting rights of the people.
Sure. The right to vote in a presidential election is one of the most sacred rights that Americans have. And in this particular case, we had strong evidence that the defendants in this case sought to interfere with, obstruct, injure that right. We had evidence, and just a couple examples, where President Trump was asking local officials to find 11,000 votes. When you find 11,000 votes, you're diluting other people's votes. We had evidence that they were targeting certain states, and particularly certain parts of certain states, generally urban parts of states, to have those votes thrown out with no factual basis whatsoever. I believe we cited this in our final report, but there's even statements of the co-conspirators in this case, at least one that's coming to mind now, specifically saying we want to get rid of these votes. We want to subtract them. And diluting the vote count in that way, there's strong precedent for that being a violation of the statute that we charged.
There were 60 federal or state court decisions rejecting claims of electoral fraud, electoral corruption that had been brought by President Trump or his teammates. To what extent did that figure into your analysis of that problem?
Well, the lawsuits, we made clear in our indictment that there are proper ways to dispute an election, and asking for an audit, which President Trump did, and I believe in only 2 of the states that were in question, that's a way you can do that. Filing lawsuits, completely legal and proper way to do that. But in this case, those lawsuits were part of our proof that put President Trump and his co-conspirators on notice. The suits, the results, and the things that court said in finding those suits without merit put him, were one component of evidence that put him on notice that these allegations were false. Also, there were instances where there were pretextual lawsuits. There was one lawsuit, for example, that was filed in New Mexico minutes before the deadline, so they could say there was a dispute in New Mexico so they could proceed forward with the fake electors ballot. There was another lawsuit in Georgia where one of the co-conspirators explicitly said in an email, we're on notice that the things in this lawsuit aren't accurate, so we shouldn't have the president sign a certification of this lawsuit. And then they played with the language a little and had him sign a certification nonetheless. And so these lawsuits, well, filing a lawsuit absolutely clearly is something you can do. They were probative evidence of the criminal intent in this case for those limited reasons I just suggested.
Can I go back to volume 2 just for a second? You said that the department gave you access to volume 2 and you chose not to use it?
That's correct.
Did,
I believe so. I did not, given the injunction, want to look at that. And so I believe it was there, but I was looking at other things. I didn't look at that.
did they give you access to any classified information that was a part of your files?
No.
Did you or your attorneys have any discussions with the department about that?
I don't recall.
Do you still have your security clearance?
No.
When and how was that taken away?
I think in the normal course of things, when you leave government service, you sign papers basically saying you don't have your security clearance anymore. It's vague, but that's my recollection of what happened at my conclusion of my service.
Do you know if your attorneys requested for you to have temporary security clearance so you could review your own files?
I don't believe we did.
And because you didn't look at the volume 2 that they provided to you, you don't know whether or not classified material was provided to you in that volume?
Again, I don't want to speak about anything that could infer the content of volume 2.
When you provided volume 2 to the Attorney General, did you provide proposed redactions?
I believe we did, but I believe we did.
And the redactions were...
But I just want to be, I'm sorry to interrupt you, sir. With the understanding that it was ultimately the Attorney General's decision whether to make it public, whether to do redactions, things of that nature.
And what were the nature of your proposed redactions?
I don't recall as I sit here now.
Was it related to the classified information?
I don't recall. It could have been 6E, it could have been things of that nature.
Did you make proposed redactions because of your concern at all about the ongoing case against Noda and Olivera?
I don't recall that, but I can't be conclusive. I really don't have a good memory of the subject.
Thank you.
I'm curious, shifting gears just a little bit. When you first sat down, the majority was asking you questions that seemingly were tied into the general duties of a prosecutor, and your resume has been laid out. It is interesting, or at least it was interesting to me to hear the majority characterize who should be prosecuted under the current circumstances. I'm not sure if you've followed along, but are you aware that under this DOJ, they have indicted Tish James as well as they ultimately indicted James Comey? Are you aware of that?
I am.
And are you also aware of the fact that this DOJ has consistently dismissed members of the DOJ for refusing to bring forth indictments that they don't believe have merit?
Yes.
The majority was asking you about why it is that you characterize your belief that there was guilt as it relates to the indictment that you sought. As a trained prosecutor, typically, are you supposed to go after people that you don't believe are actually guilty?
I'm trying to, there's a couple of negatives in that question.
I know.
Yeah.
They were trying to.
You're not supposed to go after people who you believe are not guilty.
Okay, thank you. In your experience of 3 decades, have you ever needed to seek the same indictment 3 times while being rejected?
Never.
Okay, I think that's all I have for that.
Have you ever prosecuted someone that you did not believe was guilty beyond a reasonable doubt?
Never.
As we hit, I know we're getting close to the end of our time. I want to hit on a few questions. And I apologize if they come off as very obvious to you with your experience and the way that you conducted yourself with the Department of Justice. Did Attorney General Garland or other DOJ officials direct investigative steps within your office of the special counsel?
No.
Did Attorney General Garland or other DOJ officials direct litigation decisions within your office?
No.
Did you experience Attorney General Garland or other DOJ officials interfering with your ability to conduct this investigation?
No.
Did President Biden ever give you any instructions about what you should or should not do related to these investigations?
No.
Did you ever speak to President Biden about these investigations?
No.
I think Mr. Moskowitz has a question.
Thank you, Ranking Member. You know what the definition of retribution is? Webster's definition. It's a noun.
Off the top of my head, I do not.
If I proffered that it was exacting a punishment against someone, would that sound about right?
Yes, and yes,
Your lawyers lost their security clearance, is that correct?
yes,
People who worked under you were fired, is that correct?
that's correct.
You're here today on a deposition that Sherman has brought you into, but I wouldn't give you a public hearing, is that correct?
Yes,
Did you see the comments by the President's Chief of Staff talking about retribution?
I did.
So, everyone was fired. You're here on a deposition. Your lawyers lost their security clearance. It seems like it meets not only the definition in Webster, it seems like this is exactly what Trump's Chief of Staff was talking about. No?
I have no doubt that the president wants to seek retribution against me. I have no doubt that that's the intent.
I don't want to put you off. In
Yeah.
fact, the exact quote was, he doesn't wake up thinking about it, but when there's an opportunity, he goes for it. I mean, this seems like a opportunity. Do you think the White House gave instructions to Chairman Jordan to set this deposition?
So I am eyes wide open that this president will seek retribution against me if he can. I know that. I don't frankly connect that with this hearing. I don't have any connection. I came here, I was asked to
No,
come
you
here.
think there were 0 conversations between the White House and Chairman Jordan?
I don't know, but I'm here in good faith, and I was asked to come testify.
What's the likelihood that there were less than 0 conversations between the White House and Chairman Jordan?
I'm not going to speculate on that. I will say I agree that this department wants to seek retribution against anybody who worked on cases against President Trump. I just don't have any evidence.
Why do you think
that
the Chairman wouldn't give you a public hearing?
That's not for me to say.
I want to go back to your testifying that in every case you've ever brought, you've believed that there is proof beyond a reasonable doubt to demonstrate that the defendant is guilty. I'm not sure it would be even ethical to bring a case if you didn't have that belief. But is there anything inconsistent about having that belief that you can sustain the prosecutor's burden of showing beyond a reasonable doubt all of the elements of the crime are satisfied, and also wanting to see that constitutional due process is observed in the trial? Is there any conflict between those two?
I don't see one.
In other words, as a prosecutor, you go in with the belief that you can make your case, but you also want to make that case within the rule of law and within due process. And you've never experienced that as a problem, right? You've never wanted to trample the rules of due process in order to convict someone.
That's correct.
Okay. Mark, back to you.
I just wanted to piggyback on something that Ms. Crockett brought up earlier, but are you familiar with Justice Manual 927-220?
You're going to have to give me more than the number. I think.
All right. So that provision basically states the condition with which a prosecutor can commence or recommend federal prosecution. And I can quote from that section for you. It says, prosecutor may commence or recommend federal prosecution only if he or she believes that the person will more likely than not be found guilty beyond a reasonable doubt by an unbiased trier of fact, and that the conviction will be upheld on appeal. So does that sound familiar to you?
Yes.
Okay. Did you follow this provision when you indicted President Trump in the election interference case?
Yes.
And did you follow that provision when you indicted President Trump and his co-conspirators? No, just President Trump in the classified documents case?
Yes.
And his co-conspirators? Did you
In
follow
that case, yes.
Okay. And the majority in their hour questioned you about why you included conduct that has not been found, that has not been brought forth before a trier of fact, right? That has not been proven in a court of law. But aren't you just essentially restating the standard that was that's stated in Justice Manual 927-220?
Yes. With our report, I wanted to explain my prosecutorial decisions, why we made them, the basis for them, and that's why we wrote the report the way we did.
Thank you.
In the last few minutes of our hour, please bear with me as I go through these next questions. There's a lot of inferences and accusations being made about your bias as a special counsel's office, and I want to make sure that we rebut these in the first hour. I think it's important too. So, did the Attorney General or any other DOJ official ever press you to be more aggressive in your investigation of President Donald J. Trump?
No.
Did the Attorney General or any other DOJ official ever suggest that you were expected to bring charges against President Trump?
No.
Did anyone from the White House, including President Biden, ever tell you they expected you to bring charges against Donald Trump?
No.
When you eventually did bring charges against Donald Trump, how did you make that decision? Walk us through it at a high level, if you don't mind.
Sure. It was based on the facts and based on the law. I ultimately made that decision, but I consulted with my team of prosecutors on that case, who were outstanding public servants, people with great experience in complex investigations. I took their advice and counsel in making that decision, and I tried to consider all factors, including both the strength of the case that we believed we had, possible defenses, all things of that nature.
So, which based on what you just said, it sounds like you made this prosecution decision based on the evidence in the law. Is that correct?
That's correct.
What would you have done if you felt any improper pressure from a DOJ official or the White House?
I think people who know me and have known my reputation would know that that would not end well. Someone tried to pressure me to move a case in one direction or the other where wasn't supported by the law. I wouldn't stand for it, and I would also say the people who worked in my office wouldn't stand for that either.
Yep, we're at our hour, so we'll end there. Thank you.
Mr. Jordan, you're gonna start with some stuff?
Mr. Smith, who's Marshall Miller?
Marshall Miller was a prosecutor I've worked with.
And well, let me go back to the last hour. You said the Democrats, I believe, asked you whether you lobbied for the position. And you said you didn't. But then you followed up and you said you made a call to the Justice Department, someone you knew there. And I think I got the quote right. You said, if there was the right position, I would be interested. What was the right position you were talking about?
If I could take you back, Marshall Miller is the person I was talking about.
Well, that was my next question.
Yeah, I learned that he was returning to the Department of Justice I was still overseas at this point in my State Department position. I reached out to congratulate him about coming back to the department.
And what position did he have at the department?
He was a senior position in the Deputy Attorney General's office. I'm not sure I'm going to get the exact title right, but it was a senior position in the Deputy Attorney General's
My
office.
understanding, he was Principal Deputy Attorney General, number 3 position.
That could well be.
Okay, so you called him and you told him what?
Well, I initially called him to congratulate him on coming back to the department.
Okay.
And at some point, I told him that if the right position came up, I would be interested in returning to the department.
And what was the right position?
I wasn't specific about it. I just told him if the right thing came up to sort of keep me in mind.
What did you have in mind? Do you want to go back to running the public integrity section?
So
Do you want to be a line lawyer? What do you want to do?
what I recall is right around then, there was a domestic terrorism unit being set up. And I don't know if I shared that with Marshall, but that idea that was being set up, I was interested in things like that, but I didn't have a specific.
When did the call take place?
Well, it wasn't, I'm not going to remember specific conversations. I know shortly after he returned, I reached out to congratulate him on returning to the department. At some point, I don't know if it was then or in a call after that, I said if the right position came up, I would be
And so
interested.
you're saying today, you were in no way referencing what many assume might happen, which would be there be a special counsel looking into President Trump. That wasn't on your mind. You weren't anticipating that.
When I told him I'd be interested, no.
Okay. Let's go back to where we left off in our first hour with the toll records. So you seem to indicate that you felt the burden was on the carrier to comply, and that you felt that was consistent with the statute that applies to the United States Senate. Did you feel like you had a burden at all to tell to let the carriers know that we in fact are looking for toll records for numerous United States senators?
I'm sorry, sir. Which statute are you talking about?
The statute applies to the Senate, where you reference that you think the burden is placed on the carriers to deal with this issue with senators, done by the House, but the senators. In our first hour, you said the burden's on them to, if they're going to let the Senate know that their toll records are going to the government, the burden is on them. And I'm just asking, do you feel like there was any burden on the prosecutor, on you, to tell, to make that public?
To make that public?
Not to make it public, to let the carriers know, we are in fact, make it public to the carriers, we are in fact asking for toll records for United States senators.
Sir, I don't recall discussing that particular statute. I may have. What I meant to communicate was that reading that statute as it existed at the time, reading it now, it's clear to me that the process that was envisioned.
So you didn't know about the statute back when you requested the tolls?
I do not recall discussing this statute. I can't
Okay.
recall if I knew about it then or not.
Okay, there's definitely a burden based on what the Justice Department is now going to do and move forward. There's definitely a burden now, but you didn't think there was any type of burden for you to let the carriers know these numbers we are giving you are numbers for, for United States senators.
As you referenced, the statute has now been changed. And before that change, my understanding is that the statute directed carriers to do this analysis, and in fact envisioned that carriers might get.
So there's no burden on you? No burden on the prosecutor? That's what I'm getting at.
My reading of that statute as it was drafted at that time is there was not.
Okay. And you ran the public integrity section back in your days at Justice Department, is that right?
Correct.
Did you ever get requests for toll records for this internal analysis that you think was, as Steve said pretty cursorily, did you ever get requests for members of Congress or United States senators, their toll records?
It was some time ago. I'm sure We may have. As I sit here now, I can't remember a specific instance, but I'm not
How long
saying.
were you head of the public integrity section?
I was the head from May of 2010 until it was either January or February of, I believe, 2015.
Okay, 5 years, and in that time frame, you don't know if you got, you can't recall, you may have, I think is, I'm gonna be fair to you, that you don't recall any request for the toll records of members of Congress or United States Senators.
Well, I'm saying we may well have, and
Okay.
that may well have happened. I just, as I sit here right now, don't recall a specific instance of that. I'm not denying that that happened.
Okay.
Once the department gets the records, what does it do with it? I know the FBI has something they call the Cellular Analysis Survey Team, CAST. But do you know what happens with the records once they get them?
The analysis, like how they do the analysis.
Like, what do you do with the records?
That would not be in my area of expertise, how the analysis is actually
And
conducted.
how does that get rolled back into the team?
What do you mean?
The team's work, the prosecutor's work. So you subpoenaed Speaker McCarthy's toll records after he became Speaker, and you sought records from November 2020 through January 8th, 2021. Like, what were you looking for with his records? Like, what did you do with the information you obtained?
Okay, so what the relevance of those records, there'd be several examples, but his contacts with either co-conspirators, the president, or conduits of information to the president was relevant to our investigation. And an example I could give you is on January 6th, we had information from Mark Meadows, who was present for a call where Congressman McCarthy was asking for help. He was asking the president to come to his aid while the Capitol was being seized. Getting the exact toll records for when that happened was relevant for our investigation, both to question other witnesses about, so we had an accurate timeline, and also to corroborate that the call happened at approximately the time witnesses said it happened.
But it's pretty significant to subpoena the Speaker of the House's toll records, right?
We followed department policy, and we followed all legal requirements in getting those records.
I mean, to get the information you're looking for, nobody disputed the Speaker and the President were having communications on January 6th. So one way you could have gotten that information is you could have asked the Speaker's lawyer to look at his phone records and to give you the information you needed, right?
Well, you say now that nobody's disputing, but my experience in criminal investigations is that people often at trial dispute things that you never thought were going to be in dispute during the investigation. And so when I conduct a criminal investigation, I don't assume there will be no disputes. Having a record that is a hard record about a time, and the timeline of that afternoon was particularly important because that violence started. The president refused to stop it. He endangered the life of his vice president. Then he's getting calls, and not calls from Democrats, not calls from people he doesn't know, calls from people he trusts, calls from people he relies on, and still refuses to come to the aid of the people at the Capitol. That's very important evidence for criminal intent in our case.
Right, but you could have asked Elliot Burke for that information, the Speaker's lawyer. You could have asked Elliot Burke to say, can you get us the Speaker's phone records for this time? And he probably would have said, of course. Avoiding a toll record subpoena.
And your question?
Why didn't you do that?
We got these records in a manner that was consistent with the law and consistent with department policy. There was nothing improper about how we got these records.
The same with Representative Perry's phone. I mean, you could have asked Representative Perry's lawyer. I mean, there's no evidence that Representative Perry or Speaker McCarthy was interested in obstructing your work, was there?
I don't have any evidence that Speaker McCarthy was, I don't recall any evidence, I should say, that Speaker McCarthy was interested in obstructing our work.
Okay, so with Representative Perry, you could have contacted his lawyer and you could have said, this is what we're looking for, can you help us achieve this without seizing his phone?
Well, with Congressman Perry, I should point out that the seizure of his phone happened several months before I was ever special counsel. I wasn't
Fair
involved in that process.
Yeah, okay, but in hindsight, would you have counseled taking a different avenue to acquiring a member's phone?
I'm not going to speculate on investigative steps that occurred before I became special counsel.
Okay. When obtaining the toll records of members of Congress or anyone, what is the standard? Must there be some evidence that relates to a criminal prosecution or criminal investigation?
So there has to be a reasonable basis to believe that there will be materially relevant evidence.
Okay. Now, with the chairman of the Judiciary Committee, the subpoena, with Speaker McCarthy, the subpoena, the timeframe was November 2020 through January 8th, 2021. With the now chairman of the Judiciary Committee, the timeframe went back to January 2020. So it was for a full year where, between January 2020 and December of 2020, nobody, had any telephone calls about these matters. I'm just curious why you went back to January 2020, the office did.
Sorry, I just want to clarify. When you say you went back, can we just get the date of when these
It was May
subpoenas were
1st,
issued?
2022, and it was before you were appointed. When I say you, I apologize. I mean the office, the effort. I mean, this was before you became special counsel. The DC matters were headed up by Thomas Wyndham, as I understand it,
I believe that's right.
and the Florida matters were headed up by Jay Bratt.
That's
Okay.
correct.
And so the question is, why would DOJ, why would the team seek records from January 2020, through November of that year, before any of these issues, before anyone knew about any of these issues?
Yeah, I played no role in that subpoena. I was still in Europe at the time. And because I wasn't present or involved, I'm not going to speculate on the basis for the range of time that the prosecutors in that case saw it.
Okay. After you became the special counsel, that information obtained from the subpoena, was available to the special counsel team. What did the team do with it after you became, after you were sworn in?
You mean, when you say that information, you're talking about the toll?
The toll record subpoena for the chairman of the committee.
Well, I can tell you that, for example, there was contact on, for example, January 6th, that again, another example for you is Mark Meadows. When we interviewed him, he referenced the fact that afternoon, Chairman Jordan had been in contact with the White House, and like Congressman McCarthy's contact with the White House, it was relevant because, and again, Meadows stated this, that these were supporters, these were credible people that the president relied on. And what I recall was Meadows stating that I've never seen Jim Jordan scared of anything. And the fact that we were in this different situation now where people were scared really made it clear that what was going on at the Capitol could not be mistaken for anything than what it was. And it goes back to that sort of information from someone who is a credible source to the president, proving that actually happened and that there's actually a record of that call and exactly when it happened and what actions happened after that or didn't happen after that, extremely probative to our case.
Right, but DOJ took Mr. Jordan's phone records from January 2020 through November, through January of the subsequent. I mean, what on earth could the Justice Department want with his phone records before time's relevant?
Sure, and the breadth of that subpoena was before I was special counsel, and I wasn't involved in the deliberations about seeking that subpoena or the breadth of it, and so I can't speak to that.
Okay. Can you see from our point of view that there's a perception that there's some overreach going on there?
I understand your question. I don't have any, and I do understand it, I don't have any reason to believe that that subpoena was secured for any improper purpose, or that it was secured in contravention of department regulations or the law.
Okay. And in terms of who is involved with the authorizations for that type of subpoena, it's your team, it's public integrity, any other Justice Department component?
I cannot speak to that before I was special counsel. I can say that when I was special counsel, I was the person who approved subpoenas of that nature.
Okay.
And with, of course, the fact that I wanted consultation with public integrity.
Okay. So that was the universe of DOJ authorization. It was you and public integrity. You didn't have to go to the DAG, you didn't have to go to OLC, correct?
That's correct.
Okay. When the subpoena was served for certain members of the Judiciary Committee, it was served by an official at the Department of Justice's Inspector General, which, from our point of view, raises a conflict of interest. I mean, the Inspector General is supposed to be conducting oversight, if necessary, of department components. Certainly, if department components are being real aggressive with members of Congress, we might want the IG to conduct a probe of that, right? But if the IG's on your team and they're doing this with you, that presents a problem for us. And so the question is, why was the IG's office serving these subpoenas? Why were they, they went in, I know it was before you were the special counsel, but they went on the Perry search. They took his phone and then they imaged his phone. I mean, the IG here is just like a regular part of the team. Can you explain why that happened?
Yes, with the understanding that I obviously wasn't in that decision chain because I wasn't involved in the case, but my understanding is that the Jeffrey Clark component of this investigation, he was a Department of Justice employee during the period of time that we were, and my predecessors were investigating this, and it's my understanding that is why they were involved in the investigation.
But, understood, but why, when it comes to members of Congress, didn't, like, I don't understand, like, yeah, I understand they had the Jeffrey Clark investigation going on, but when it comes to members of Congress, I mean, the IG has a special, relationship with Congress. Why are they allowed to be involved?
Again, all I can tell you is what I just told you. This was before my time, but my understanding about why it occurred is because they were involved in that aspect of the investigation.
And were they involved after you became the special counsel? Were they involved in serving toll record subpoenas related to members of Congress, to your knowledge?
My recollection is that they may still have been involved. My primary dealings were with the FBI, but they may well have stayed as part of the investigation. I didn't have a lot of interaction with them.
Okay. And when some of these toll record subpoenas were served by the IG's office, do you know whether they knew they were serving toll record subpoenas relating to a member of Congress?
Are you talking about in the period of time when I was special counsel or before?
When you were the special counsel.
Okay. As I sit here, just to be clear, I'm not aware, I don't recollect that people in the DOJ Inspector General's office were serving subpoenas during my time.
Okay.
Could well be. I just don't have recollection of that.
Okay. I can represent to you that they did serve subpoenas before your time. I mean, they served one in May of 2022 relating to the chairman of the committee.
Yeah, and as I said, before my time, I can't speak to that because I was in Europe. I wasn't in the investigation.
But after you became, after you were appointed, that wasn't occurring to the best of your knowledge?
I just don't have a recollection of that.
Okay.
But I want to just to be clear, I'm not sure. In my role, I would know which individual agent was serving a subpoena, so that's not something I would have necessarily known in the first place. Just, I wanted to make that clear.
Fair enough, but if it was from the IG's office, wouldn't that raise like an issue?
I'm just saying to you, in my role, I was not like directing which agent would serve which subpoena.
Okay. Did you have interactions with the IG's office on the Jeff Clark matter?
I can't think of any now, but I don't want to say that it may have been possible I did, but as I sit here now, I can't think of any.
I mean, were they a part of the team after you were appointed?
That's what I said earlier. My recollection is that they were.
Okay. With the toll record subpoenas for the senators, one of the lines requested was a Senate landline. Did you know about that?
I don't recall knowing about any particular lines. My role, as I saw it, was to understand who my prosecutors thought we should be getting toll records for, to make sure we had a basis for that under the statute, a reasonable basis. I don't recall discussions about how they figured out what lines we would be going for.
Because at least in the House, if you place a call from a landline in the House, it goes out scrambled. So, to the extent DOJ thinks they have the right number, it would be scrambled. And so it's just raises questions as to why the office would subpoena toll records for a Senate landline. And you don't have any additional information or recollections on that?
I really don't.
Okay. There was some litigation with AT&T over the subpoenas for the Senate lines. Do you have any recollection of that?
Was it litigation, or I know I saw, or I was shown that there was a letter that from AT&T to Senator Grassley. I don't recall any litigation.
Okay. Maybe litigation was the wrong word, but AT&T, I guess, pushed back on the toll records subpoena. And according to them, after they pushed back and said they weren't comfortable producing the records, the special counsel's office stood down. Do you have any recollections from that?
I don't have any recollection of that.
Okay. And essentially AT&T represented, at least to Senator Grassley's office, that after they said no, we're not going to give you those records, your office didn't press the matter further, which raises the question why. But your testimony is you don't have any recollection of that?
I don't have any recollection of it. I also don't know from the letter what the reason they gave for not giving it, but I don't have a memory of any of this.
Okay. To the extent members of Congress and senators are up in arms that this happened to them and they're seeking accountability, who should be held accountable for answering these questions?
Well, I think who should be accountable for this is Donald Trump. These records are people, in the case of the senators, Donald Trump directed his co-conspirators to call these people to further delay the proceedings. He chose to do that. If Donald Trump had chosen to call a number of Democratic senators, we would have got toll records for a number of Democratic senators. So responsibility for why these records, why we collected them, that lies with Donald Trump.
Well, I understand that's your perspective, but in terms of there are calls from United States senators to impeach Judge Boasberg because he signed this NDO order. We've asked you questions, for a good bit now about whether your office should have taken additional steps. So it's either your office, the judge, the carrier. In your view, who needs to be held to account on these toll record subpoenas?
Well, I don't, certainly my office did everything consistent with the law and department regulations at the time. As I think we referenced earlier this morning, the department regulations on this, since we issued these toll records, has changed. If, I believe now, and I believe this is in 2024, if we were to make an NDO application to a judge, we would need to identify if they were members of Congress. And so, to the extent you think something needs to be changed, that change happened.
Okay.
But that was not required at the time that we issued these subpoenas.
Okay.
Sort of begs the point there, doesn't it? Don't you think? Sort of begs the point, like, it makes the point, like, maybe that should have been the standard, it should have been a burden on the prosecution to actually give that information to the carriers. Would you agree?
No, as I said earlier, I think we followed the regulations that they existed at the time. If the regulations that are now in effect were in effect then, we would have followed those regulations.
I just want to circle back for a second. Who first contacted you about taking the position of special counsel?
Marshall Miller,
Same guy you reached out to early on,
correct.
who said you'd be interested in the right position. So when did he call you?
It was some point, I told you earlier, there was this initial conversation where I said.
Understand that.
Right. Some point after that, he contacted me about ultimately the position that I ended up having.
Okay, and I'm trying to find out when that was, because you called him when he took the job in the summer of '22, which is before President Trump announces he's running for president, before you get appointed by the Attorney General. I want to know when you talked to Mr. Miller the second time, or the third time, or how many times did you talk to him?
Between the time that I originally reached out to Marshall Miller and the time that I was appointed as special counsel, I spoke to Marshall Miller several times.
Several times, okay. And then he's the one who first asked you, would you be interested in being the special counsel, is that right?
I don't remember how he phrased it, but my recollection, to the extent I have one, is it was not phrased in terms of being the special counsel. I think it was in terms of being involved in these investigations.
And again, when was that?
I'm having trouble recollecting. It definitely was after he first reached out to me.
Wait. I thought you called him first.
I'm sorry, you're right.
Okay.
I after I first reached out to him, we had multiple conversations between then and when I was
Between the
appointed.
summer of '22, when he takes a position as number 3 guy in Justice Department, and between November 18th, 2022, when you get named, you had multiple discussions, multiple conversations.
Yes, I just also to be clear, not all of those conversations were about this position.
I'm not saying you were, it was
Okay.
multiple conversations. Did he ask you to, did he talk about special counsel position, the one you took, prior to the Attorney General asking you to take the job? I thought he said yes to that earlier.
Yeah, what I'm trying to remember is my recollection, and it is a little vague, is that the idea that working on these cases would be in the format of being a special counsel. My recollection, that it's imperfect, is that was very shortly
Okay, so
before
what
I
did he
was
say? Did
appointed.
he talk about Arctic Frost? Did he talk about Plasma Gecko? Did he talk about these investigations, the Florida case, the DC case? What did he talk about?
I don't recall him ever talking about Arctic frost or plasma. I don't remember.
Those are some names. Did you talk about the 2 cases?
Yes, at some point it was not clear to me whether, when he first, my recollection again, and it's not perfect, is it wasn't clear to me if it would be working on one case or the other or both. I'm not clear of how that first came up.
Okay. And these conversations were before President Trump announced that he was running for president?
Yes.
Okay. And were they before the midterm elections in '22?
When were the midterm elections?
November, first Tuesday after the first Monday in November.
I think I spoke to him both before that and after that.
Okay. And then, how did it go down at the end? Did you tell Mr. Miller, you know what, President Trump's announced, they may be considered, how did it go? Did you just tell Mr. Miller, I'd be interested if there's an official special counsel, or how did it go after President Trump announces? How'd that conversation go?
My recollection of this is that I was asked if I would accept the position if it were offered to me, and that was before President Trump announced his candidacy.
When you were sworn in as special counsel when you were in Amsterdam, is that correct?
Yes.
Who swore you in?
I don't recall.
And was it over Zoom or something?
Don't recall.
Or was someone present? Was, Mr. Cooney, or Mr. Cooney and Brad and several folks came to visit you in Amsterdam, is that right?
Not in Amsterdam. I was in The Hague, in the
Okay.
Netherlands. They probably flew into Amsterdam.
Okay.
Yeah. And yes, they came to see me shortly after I was appointed.
But you don't remember who administered the oath? Who can administer the oath? Like, who's authorized the DOJ to administer the oath?
I don't know.
But you did take an oath. You remember that?
I do recall that, yeah.
But you don't remember whether it was was it in the Netherlands?
I was still in the Netherlands, is my recollection.
Okay. So it had to be either a DOJ official came to see you, or it had to be over Zoom, right? Those were the options?
Or over the phone. I really don't have a recollection that I can help you here.
Okay. And do you know the total cost of your probe?
I do not.
Rough, can you give a rough estimate? Or?
Well, the special counsel, our office, consistent with past special counsels, gives a public report of expenditures. And the last, I'm not sure if the last one that would cover the last however many period of time was ever actually published. And so you'd have to add that into the total.
Okay.
So that's why I say I don't know.
At the time, the last published report, I think it was at 20 million.
Okay, I don't recall that. Whatever is in the public reporting on this would be accurate.
Okay. The genesis of the alternate electors case started with the National Archives IG. Is that your understanding? They first raised flags that they were receiving alternate electors to the Justice Department.
That I believe would have been well before I was special counsel.
Okay. And when you became special counsel, was that part of your, where did the alternate electors case stand, when you became the special counsel in November of 2022?
So the fake elector scheme was part of what I was investigating, and it ultimately became part of the charges in the case.
Okay. But where did it stand as of November 2022?
Where did it stand? I think the people assigned to that investigation were investigating it. Exactly how many interviews they conducted, things of that nature, I can't recall as I sit here right now.
Before you became the special counsel, there was an effort to get DOJ moving on this, and an individual named Amanda Vaughn, a prosecutor on J.P. Cooney's team, indicated that the DOJ would not be pursuing the case. Were you aware of that?
Was this when I was special counsel?
This is before you became special counsel.
I don't recall that.
And so the question ultimately is it seems like the alternate electors matter, it seems like it was subject to a lot of starts and stops. And wanted to know whether, after you became the special counsel in November of 2022, were there any starts and stops, or was that full speed ahead on that probe?
That was a part of the case that we investigated from the time I started until the indictment. It ended up being one of the most powerful parts of the case. We had electors who were going to be witnesses. I referenced earlier a congressman from Pennsylvania who had said this was an attempt to overthrow the government. We had other electors who said, I was told that this would only be used if we won in litigation, and obviously the record in our case showed that the co-conspirators were trying to use their elector votes, despite that fact, and again, this goes to the point I made earlier, these are people who wanted to be electors for Donald Trump. They are not people who are opposed to him. They were not people who are from a different political party or enemies. And so the fact that we had elector witnesses like that, who felt either they'd been misled or they felt that this whole effort was an attempt to overthrow the government, I thought that was pretty powerful evidence. And so we moved that part of the investigation forward with the rest of the case.
Did your office coordinate with state officials?
You mean interview state officials?
No, coordinate, several other, state probes cropped up, in Arizona, in Fulton County, Georgia. And I'm wondering how you coordinated those efforts.
I know that we got inquiries from state authorities. I'm aware of that. My recollection is that we did not share any evidence with them. And I don't think, my recollection is we did not get any evidence from them. We got it from, that is my recollection, that it was all or largely from public sources.
Okay. Was there somebody on your team who had responsibility for liaisoning with the Attorney General for the state of Arizona, Chris Mays?
I don't believe so, but also the liaisoning, I don't think that, my recollection is that there was not like an ongoing discussion. What I was thinking of, I know we got a letter, for example, from the Attorney General in New Mexico asking for information from us. I don't have a specific recollection as well as to other states. It may well be that we got other inquiries.
So there was no proactive coordination?
No.
Okay, there was no proactive coordination, regular communications with Chris Mays' office in Arizona?
I don't recall any regular communications, but I'm hesitating just because I don't recall, as I sit here, how many times they might have reached out to us or that sort of thing.
Right. How about with the Fulton County DA's office with Fonnie Willis and Mr. Wade?
Yeah, I've never had contact with either of those people.
Okay, do you know if anyone on the special counsel team, on your team, had contact with them after you were appointed in November of 2022?
I don't believe so. I will just say, though, that one of the things we were investigating was things that happened in Fulton County. Particularly, there was an election worker by the name of Ruby Freeman, her mother, and she was the mother of a woman named Shay Moss. They were people that Rudy Giuliani and Donald Trump targeted with absolutely false claims of election fraud, claims that Rudy Giuliani later admitted he didn't have evidence for, claims that he was held liable in defamation for, caused them to endure all these sort of vile threats. And that whole episode, as well as sort of the claims, the false claims about the vote count in Fulton County, we did look into that and collect evidence. I don't have a recollection, as I sit here, that we interacted with the Fulton County DA's office for that, but if we did, it would be only for that.
Okay, did you try to deconflict their prosecution from what you were working on?
Well, we didn't, I was not interested in sharing information with them, so I did not give them information. I'm not even sure, testing my recollection now, but I don't even think we got a request for information from them.
Did you have coordination as far as scheduling was concerned?
I don't recall anything like that.
Okay. Because their proceedings were going on concurrently with your DC case, with the Florida case. So you don't remember you or anyone on your team having communications with Fulton County to coordinate scheduling?
No, I was aware, obviously, that their case was pending, but I did not coordinate any scheduling with them.
Okay. How about with the Attorney General for the state of Michigan?
Again, it may be that they requested information from us. As I sit here right now, I should say I don't have a really good recollection of this subject matter you're talking about, but I don't recall us giving them information, and I don't recall getting information from them.
Who on your team would have that, that information?
Well, Thomas Wyndham and Molly Gaston led that case, and
Okay.
along with J.P. Cooney, that would probably be
Okay.
people who might recall these things
Okay.
with more specificity than I am.
Okay. So if somebody has the information, one of those three people should be able to help us?
There may be other people in the office as well. I'm saying them because they were the direct supervisors of the prosecutors on that case, and they may have a better recollection.
Same question with the District Attorney of New York's office. Did your office have any communications with that office, coordination?
No recollection of that.
Did you have any communications regarding scheduling?
Again, I have no recollection of that. I was aware of their case pending, but I don't recall any coordination with them.
Did your office or anyone at DOJ, to your knowledge, try to dissuade the District Attorney of New York from bringing that case?
I do not recall that at all. And that I'll just say I have a better memory. I do not remember anything like that.
Were you enthusiastic that the District Attorney of New York was bringing that case?
No, I didn't take any position about it.
Okay, because, it was going on at the same time that you were trying to move forward your two cases, correct?
Correct.
And you didn't have a view that the case out of the District Attorney of New York's office was going to be a distraction? Litigating whether there's payments to some performer and how that relates to, the Trump Organization's accounting protocols. I mean, that is very different from the two cases you were pursuing.
Yeah, the two cases are completely different.
And so the question was, do you think that the District Attorney of New York's case presented a distraction for what you were trying to accomplish?
A distraction. I don't know that I thought about it that way. I can't recall any discussions along those lines.
I mean, there were a number of times when you wanted to be in court in D.C. and you had to work around the president's schedule because he was in court in Manhattan, correct?
I'm not sure that's right. Maybe that's right. I don't know if there's a record about that. I don't, was there, if, I shouldn't be asking you questions,
Yeah.
but is there, I don't recall.
Yeah, there is.
Okay. So I'm not disputing you then.
I mean, one of the issues is, the president was represented by, he had his team of lawyers. It was pretty small group. They weren't backed by big law, right? So they didn't enjoy a robust, hundreds of, lawyers back at the office to be able to digest some of these things. And so, President Trump's lawyers, were required to be in New York part of the week, and then they had to come to D.C., and then they had to go to Florida. And so the question is, did you ever coordinate with the District Attorney of New York to, maybe not be at trial one day so you could have the president and his lawyers here in D.C.?
I don't recall that.
Okay. And was any of that a distraction?
It wasn't a distraction from us because, as you said, that case had nothing to do with our case.
Okay. There were a number of times that I believe Jay Bratt took the position that the president ought to go get some more lawyers. Like if Todd Blanche and John Lauro, if they can't handle all these cases, they should just go find different attorneys for President Trump. Were you aware of that statement by Mr. Bratt?
What context was that?
Before the court in D.C. and Florida. Actually, Mr. Bratt was in Florida.
Yeah, I don't think Mr. Bratt appeared in court in D.C.
In Florida, I'm sorry.
If you could direct me to specifically what he said, as I sit here now, I don't
Okay.
recall that, but I'm not denying that happened.
Maybe we'll revisit that, but we can point you to
Sure.
But you would certainly agree that the president gets to pick who his lawyers are, and if he wants to have Todd Blanche and John Lauro and not others, that that's something that the government ought to be able to work with, correct?
Sure, although, not this case, but other cases, I've seen judges say that if you're going to pick lawyers because they're unavailable, that you can't do that. And if
Well, that
you're
wasn't the case here.
Well, if you're picking lawyers because they, that will allow you to sort of delay the case,
Right.
that's not something that judges usually put up with.
But, President Trump, nobody from Big Law would represent him. Isn't that a pretty well-established case?
I don't know that.
And like Mr. Blanche had to leave his firm to take on the representation?
I know he chose to leave his firm. I don't know the circumstances behind that.
Maybe it comes as a surprise to you, but there are, really two different Washingtons when it comes to lawyers. And, Big Law downtown just does not, have a great appetite for hiring former, Trump alumni, lawyers that worked in the Trump administration with, Republicans generally. Are you aware of that?
I have not worked in big law. I've been a public servant my whole career.
Right.
That's the world I know.
Okay. By contrast, the lawyers on the January 6th committee, they leave the Hill one day and, they're immediately gobbled up by Big Law very quickly. That just doesn't happen with Republicans. Would you agree?
That Republicans don't get jobs as lawyers? I'm sorry.
At big law firms.
I don't actually know that that's true. Again, this isn't a world I have worked in, but I think there are Republicans at big law firms.
Okay. Republicans that represented Donald Trump zealously?
I haven't kept track of that, but you'd said Republicans at law firms, so.
When your office filed its proposed DC schedule in August of 2023, were you aware that your office also had a concurrent schedule, operating in the Southern District of Florida? You essentially had two cases going at once.
Correct.
And so how did you deconflict those scheduling appearances?
Well, there were two separate groups of lawyers working on those cases, one in the classified documents case, one in the investigations case.
Was that the case for President Trump?
I'm sorry?
Was that the case for President Trump as well?
I'm trying to recall. I know John Lauro, who I think was the lead counsel in the Washington, D.C. case. I don't believe he had any involvement in the Florida case, and I know Christopher Keiss, I think was his name, was in the Florida case and didn't have any involvement here. I don't know,
Okay.
also I should say, I don't know how many lawyers supporting the lawyers in court President Trump had that were supporting one case or the other case.
In February of 2024, your office proposed an April hearing in the Southern District of Florida. At the time, you were aware that President Trump was scheduled for a full-day jury trial proceedings in New York on April 1st, 2nd, and 4th. So your proposal required the president to attend trial in New York on April 1st and 2nd, travel to Florida for a hearing on April 3rd, and return to New York for trial on April 4th. Do you recall that type of extraordinary logistics the president was put through?
Can you say that back to me? I just didn't, you said some dates in the beginning, if I could just hear it again.
On February 29th, 2024, your office proposed an April 3rd hearing in the Florida case.
Okay.
At the time, President Trump was scheduled for, full-day jury trial in New York on April 1st, 2nd, and 4th. So you picked the 3rd, the one day that he had off from trial. Does that ring any bells as we refresh you about that?
It doesn't ring bells, but I want to be clear, I'm not denying that those dates are accurate.
I mean, do you think that's reasonable in hindsight?
I think our requests to the court were reasonable, yes.
And you think it's reasonable that President Trump had to be in New York on the 1st, 2nd, and 4th, and then travel to Florida on the 3rd?
I think our requests were reasonable, yes.
So just to clarify, what kind of hearing was it? You said a hearing in the Southern District of Florida on April 3rd? Is there any more information about what kind of hearing it was? I mean, was it just a status conference or something different?
As we understand it, President Trump had to be there. I think, if it's a status conference, I'm sure the judge would. We only have about
That's so you
nine
can move
minutes
on.
left, so we'll-
I didn't mean to
Yeah.
delay things. No, you can keep going.
Just keep it.
Okay.
Mr. Smith, can I just ask a few questions? When you were hired in November of '22, how did the department educate you about the predications for the investigation? What evidence had been collected?
I got educated on the cases by debriefing with the people who were leading the investigations.
And in terms of when that full autonomy was handed over, how quickly did that happen?
Sure. So I was appointed on November 18th, that Friday. And time difference, right, because I'm in The Hague.
Yep.
I requested that evening that someone get on a plane to come over and debrief me immediately.
Who that was?
It was J.P. Cooney was the first person who came over.
He came alone?
I believe he did, in my recollection right now, and I think he got there, maybe it was till, I can't remember if it was Saturday or Sunday, but he got there Sunday and began giving me a summary of the work.
And was that just digital case files? Was it hard copies?
It was oral.
All oral?
He came over to debrief me orally, yes.
When was the first time you started to look at some of the materials? Only reason I'm asking,
Yeah.
DOJ alum, when I got an investigative memo, I would start going through and looking through the materials myself.
I did that.
Yep.
I'm having difficulty remembering exactly when that happened, but I certainly did that. It was early on.
In terms of the way you approach this, did you go through and kind of review the predication for all of the investigative steps that have been taken to that point?
Review the predication for all of this.
So whether it was, pen registers, search warrants, did you review all of that, or were you just looking at kind of the summaries of the information, the evidence that had been collected?
I think I was looking at kind of the overall where the investigation was at this point in time.
Okay. In terms of the staff decisions that you made, how soon did you start staffing up your office?
Well, the office was primarily staffed with people who had already been on the investigations. The majority, I think, were people who had already been on the investigations, and so there was a period of time shortly after I appointed where we had to determine, they had to determine if they were going to stay on the investigation.
Did you ultimately make that decision?
Yes.
Okay. Did you go and meet with every one of those individuals?
I was still in The Hague at that point in time, and so J.P. Cooney had those meetings.
In regards to the law enforcement officers, did you have any say in which agents worked for this investigation?
The squads that worked on these investigations were the same squads that were already working on the investigations when I took them over.
Did you amend those, that personnel at all?
The FBI?
Yeah.
I don't recall doing that.
Okay. And then just to follow up on what he said, was there ever any contact between you or any of your team with some of those other prosecutorial offices, whether it be DA, AGs, for the purposes of evidence sharing, information sharing?
Yeah, as I said earlier, I don't have a recollection of that.
But was there a policy as the boss of the office? Did you have a policy with that? If someone had done that, would they have had to report it up the chain to you?
Yeah, if someone had said, I want to call Fonnie Willis and have a conversation and get evidence from them, I would expect no one would do that unless I said it was all right.
And in your recollection, that never happened?
I don't have a recollection of that. As I said, I just want to be as clear as I can. I don't have a great recollection of specifics with different Attorney General's offices, but my recollection is we did get reached out to by offices. I'm thinking of one letter I do recall. May have been, yeah.
Other officers reached out to you?
Yes.
Okay.
That's what I recall.
Yeah.
And so there may have been interactions as that result. As I sit here, I don't recall asking them.
You initiate?
Or asking them for evidence, but again, I think, as I directed, I think the people who are the team leaders on those cases and JP Cooney might have a closer recollection of that.
Okay, but your memory is there was no outreach that you had to approve or sign off on?
Outreach that I did sign off on, I don't recall anything like that.
And who did the letter come from? Again, just refresh my memory. So you got one letter?
Only one I remember is I remember we got a letter from the Attorney General in, I believe it was New Mexico. That's my recollection.
Okay. Anyone else in the Justice Department, just again to circle back, you talked about the series of conversations you had with Mr. Miller, the KDAG. Anyone else in the Justice Department you talked with prior to Mr. Garland offering you the position of special counsel? You talked to the DAG, you talked to Lisa Monaco.
Well, yeah, so I flew to the United States from The Hague at some point in late October, and I met the Attorney General and I met Lisa Monaco. That was in late October of 22.
Okay. And anyone else in that meeting? Was Mr. Miller in that meeting?
So it wasn't a meeting, it was separate. I was at the DOJ, I met with Lisa Monaco, and then separately from that, I met with the Attorney General. I do recall the meeting with the Attorney General wasn't that long. Matt Clapper was present for that meeting, and I believe Marshall Miller was present for that meeting. With regards to Lisa Monaco, I cannot recall if Mr. Miller was there or not. He may have or he may not have been.
And the subject matter of both meetings, one with Ms. Monaco and the other one with Mr. Clapper and Mr. Garland was what?
They asked me about my work in The Hague. That was what both conversations were about. And I just also add, that same trip, I also went and spoke to the Human Rights section at DOJ about the work I was doing in The Hague for the State Department.
And that was all? That's all you talked about was your work at The Hague?
My work in The Hague and sort of like my experience as a prosecutor, my sort of how I viewed the job. We didn't talk about these investigations, to my recollection.
In hindsight, was it an interview?
In hindsight, yes.
Okay.
But
okay, go ahead.
in hindsight, yes, but it wasn't in the sense of I wasn't asked about. I don't recall being asked about these investigations.
Fair enough. In your conversation with Mr. Miller, had he already communicated to the Attorney General and Lisa Monaco that you were interested in the special counsel position, if in fact that was going to be done?
I wouldn't know.
Sorry, I just want to clarify the timing on that. This was end of October 2022, and Chairman Jordan, your question assumed that there was discussion about the special counsel position. Did Marshall Miller convey that to Lisa Monaco or Merrick Garland that Mr. Smith was interested in that position? I just want to clarify, because I thought I heard you say earlier that the discussion was not necessarily in context of a special counsel appointment, or is that not right?
Well, they asked me about my work in The Hague and my work as a prosecutor. I don't know what conversations Mr. Miller had with them.
Fair enough.
When I wasn't there.
But you said earlier you had conversations with Mr. Miller about the two investigations, not special counsel specifically, but about DC investigation, Florida investigation. And then you've also said that in the meeting with the Attorney General and Mr. Clapper and the other meeting with Lisa Monaco, you didn't have discussions about those two investigations. Is that accurate?
That's right, with the addition that I can't place when the conversations about generally working on the investigations was, but I think my recollection, to the extent I can remember this, is that it was sometime before I took this trip to Washington DC.
So those conversations with Mr. Miller about the investigations took place prior to you sitting down with the Attorney General and the Deputy Attorney General?
I believe that's right, but I want to emphasize that my recollection here is not as sharp as it has been on other subjects that we've talked about today.
Okay, hour's up, so we'll just stop. The April 3rd hearing was a pretrial motion.
Okay, thank you.
Doesn't matter. You can leave it on.